Yes.
Original side mentioning.
May I, my lord's kind leave to mention one matter, my lord, for section 34 application, my lord, for transferring the matter to commercial division, my lord. It is of 2020.
2020.
2020. Inadvertently, it was not done, my lord.
You realized after 3 years.
My lord.
That is a commercial division matter.
It's a commercial division matter. My lord, the involvement is total claim is 208.9.
When was the matter last heard?
My lord, the matter was last heard in 2021. When it
2021.
was admitted, my lord. And thereafter, several times I have mentioned for inclusion in the list, but
Get the other side, we shall see.
my lord, I have served notice to the other side.
Maybe. Get the other side, then we shall see. Yes.
Maybe.
My lord, the other side is appearing.
I'm appealing for the respondent.
Yes, what do you have to say?
Your Lordship, you can keep the
We
matter.
mentioned tomorrow.
Deeply obliged, my lord.
Lordship may be permitted
That
to
doesn't mean that I will transfer the matter.
may be permitted to mention an application under section 9 for extension of interim order. The Lordship, last interim order was passed on 26th of April for 8 weeks. It's expiring on 31st of July.
My lord,
May
I
it
appear
appear.
for the other side, my lord, for the respondent in this, my lord. My lord, I appear for the respondent in this, my lord. There's no scope of extension of this interim order, my lord.
Let it come. The matter is always listed. Then we shall see.
Grateful.
Yes,
Alert.
it's expiring when? 30th?
31st
31st.
on Monday.
31st to be mentioned.
Grateful. Your
My lord, may I be permitted to mention a matter, my lord, upon notice, my lord, under section 34 of the Arbitration Act, my lord. It is a specially assigned matter before your lordship, which was earlier heard before your lordship in January 2023, my lord. Thereafter, the matter had been appearing in the list, but was not called, my
Why
lord.
is it specially assigned?
Because earlier, my lord Justice Ravi Kapoor or Mr. My lord Justice Shekhar Saraf had released the matter, my lord.
So after January, what steps did you take? For
The
hearing the
matter was appearing in the list, but it could not be called. We had mentioned, my lord.
Yes, 3rd week of July, 3rd week of August. Yes,
My lord, may I mention another matter, my lord, for
you have
inclusion?
to wait.
My-
Step
And
back.
give Millard to mention Millard an execution application, new chamber application for inclusion. New chamber application.
So why are you mentioning? It will be listed.
No, it was Millard due to Millard, it was taken by Justice Kapoor. Millard, then Millard, the determination changed. It was due to appear on 6th July. Now Millard, we are mentioning any day Millard for a list.
2nd week of August.
Lordship, may I have your leave to mention a execution application, Lordship? I had last mentioned it on 13th of July. Lordship had asked me to mention it today. Lordship, the matter had last appeared on 4th of January 2023. It was adjourned for 12 weeks, Lordship, because there was a section 34 which was pending. Lordship, the section 34 before the Alipur court has been dismissed on 26th April 2023. The hypothecated asset is with the receiver, and Lordship, it is deteriorating. I was paying for, I will be paying for sale orders.
What is the asset?
Lordship, it is a backhoe loader.
Yes, 8th August, notice to the other side.
My lord, your lordship has appointed Mr.
Microphone.
Snehasi Chakrabarti as the arbitrator. My lord, unfortunately, despite best efforts, we could not locate him.
Isn't there an advocate called Snehashish Chakrabarti in the bar library? He's mentioned, he's appeared in my court. Young lawyer.
My lord, in fact, we tried to search in the bar association as
You
well
don't
as
have to
the.
search much.
My lord.
Wait. I'm asking a question. You wait, please. Yes, who is here from the Mr. Dotto? I thought there's an advocate called Snehashish. Maybe I've got the surname wrong, but he's a fair young lawyer who appears in the, and I wanted to appoint him.
My lord, possibly he is not a member of the bar library. We'll try and my lord find it, and my lord will inform your lordship, my lord, regarding the my lord, sir.
Yes, because he appears once or twice in my court after in this determination, and I thought he's a young lawyer, so I'll appoint him.
My lord, he knows possibly, my lord, Mr. Pondaval.
My lord, he's not a member of the library, neither a member of the association, yet to take membership one of the wings of the.
Yes, so all the more reason why I should appoint him. Yes, please give him the number. Thank you very much. Please give him his number.
I shall. Extremely.
I have your lordships kindly, my lord, to mention.
Don't
Lord-
fall asleep while mentioning. Use the microphone and mention properly.
My lord,
Yes.
well, I am praying for leave, my lord, to file 2 review applications without the certified copy of the orders. The difficulty is, my lord, the section 11 proceedings, my lord.
You don't think it's important to mention the date of the orders?
My lord, certainly.
Yes,
The
what
orders-
yes, what is your mentioning? Come back. Come back
Wait.
on the next day.
Lordship,
Yes.
the orders
May it
are
please
passed in
your-
July.
Come back on the next day. Yes.
May it please your lordship to mention a matter, my lord. It's my execution application for executing the reciprocal promises and terms of settlement, your lordship. Now, one of the reciprocal promises was the fact that they had to release my personal guarantee in the matter, my lord. Now, there is a sale notice of the immovable properties of that loan where I'm a guarantor has already been issued, my lord, which is why the interlocutory application that has been filed by the judgment debtor for dismissal of my execution, my lord, is appearing in the list as item number 31. I'm only humbly playing if my execution could be upgraded, my lord, due to the
And
subsequent
when is the
circumstances.
34 due to appear in the list, you said?
Your lordship,
The interlocutory application for
the
dismissal?
interlocutory application is appearing in the list as item number 31 with my execution application. I'm only humbly praying if my execution application could be given some preference, my lord, due to this sale notice.
Very
that
well.
has-
31, it will be called on today. You please wait and see what happens. Yes.
Grateful, my lord.
Yes.
Let's kindly leave to mention two matters, my lord, for withdrawal. Warrants are pending in these matters.
Yes, to be mentioned, are you mentioning upon notice?
No, my lord, there is no other side.
Yes, to be mentioned on Wednesday. Yes.
May I have asked kindly, to mention a matter, my lord, I had
Mr.
mentioned.
Sinha, you have to wait. All those who were here before you. Yes, yes.
Lordship, this is a section 34 application against my client. Lordship, this matter has appeared on 3 occasions on 2021 and 2021 twice. However, the petitioner has not represented themselves. I'm praying if
You're
the
the
matter.
degree award holder.
Yes, your lordship. I'm praying if this could be included in the list and.
Yes, on 1st August, notice to the
Grateful,
other
your
side,
lordship.
please.
Your lordship, may I permitted to mention one section 11 application of 2021, your lordship. Pleading has been completed in the matter. Opposite affidavits has been filed. I'm just praying for an inclusion in the list.
When was the reply filed?
Reply has been ready, but after that matter, they couldn't take it up. So affidavit replies is ready to be filed. And
Last heard when?
2021, September
Yes,
2021.
you please wait and mention in August. Yes.
Sir, may I be permitted to mention a section 11 application for inclusion in the list? This matter had last appeared on 19th of January when it was directed to be returnable on 19th of February. My lord, thereafter, because of change of determination, it had not come up in the
19th
list.
of February, there was a change of determination?
No, my lord, thereafter, my lord, it was running in the
Very
list.
well. You wait till
My lord-
August and mention.
But it is only for.
Yes, yes, Mr. Dotto.
Appellate side matters, so I'm being-
Yes, yes.
May I list to mention, this is an execution application, not along with not an application filed with judgment debtor. Not this was not last heard, not in September last year, not. It was thereafter it appeared in the list, then thereafter it was not taken up. Not I had mentioned this matter, not on 6th of July, not for inclusion. Your lordship asked me not to mention not in the last week of July, not if it could be.
Yes, 16th of August.
I'm
Notice to
grateful,
the other side.
May I be permitted to mention this? This is an execution application. I mentioned this on 10th of July, Malat, or 2023, Malat. Your lordship instructed me to mention the last week of this month, Malat, which I'm doing today, Malat. I'm praying for inclusion of the matter in the list, Malat.
Last heard on?
It was taken up on 24th of April 2023 when there was a direction for service and returnable 8 weeks hence. Malat.
Yes, last week of August. Yes.
May I have your lordship's kind leave to mention
Keep
this
your-
matter, my lord?
I
In this
can't
matter-
hear you.
In this matter,
Banerjee.
judgment has been passed by your lordship on 10th July 2023, my lord. There is one mistake in the amount, my lord, the last page of the judgment. Not finally come to.
Very well, to be mentioned tomorrow.
My lord, may I have the liberty to mention this section 34 application, my lord? It was filed in September 2022, my lord. Thereafter, once it was dismissed for default.
Yes, in August. Yes, any other original side mentioning?
My lord, may I be permitted to mention, my lord, section.
I asked you to step back. You will mention only when I ask you to.
May I
Yes.
be permitted to mention upon notice for inclusion of section 11 application, this matter was heard on February 2023, wherein direction for filing of affidavits were done, my lord. My pleadings have been completed, my lord. If my lord kindly direct to for
It's
inclusion.
mentioned in August. Yes.
And I'm praying for leave to mention a matter upon notice for inclusion in the list. It is a application under section 34, my lord.
Last heard on?
My lord, last it was heard on 20th September 2022 by my lord Justice Shekhar V.
Very well. Mention in August.
Lordship, with your permission, may I mention an execution case, lordship? I am for all the judgment debtors in the matter. This matter was last heard on 8th of May 2023. At that time, the judgment debtors were.
I can't hear you. You have to
Lordship,
use
on
the
8th
microphone.
May 2023, at that time, all the judgment debtors were unrepresented. As a result, affidavit of assets were not.
Yes, second week of
filed.
August. Appellate side mentioning?
Side mentioning.
May I be permitted to mention this matter? This is a part matter.
Master.
This is a part matter, my lord. There's matters relating to the family pension of those petitioners, those who retired before 381. My lord, this matter was heard on September 2020, but there are one appeal has been pending that now the appeal has.
I will put it in the list and release the matter.
No,
All
my
right?
lord, but
No,
your
no, no,
lordship has heard
please.
the matter.
Mr.
The matter is
Mr.
no
I
more
have
pressing.
heard many matters, but now there's a regular bench for hearing these matters. Go before that bench.
What happened, my lord? Only because an appeal had been prepared, your lordship has recorded.
Very well.
and it
Yes,
was a-
last heard on 2020. I don't remember family pension. There's a bench now. Please go for that bench. I will list it tomorrow and release it.
My-
Yes, to be mentioned tomorrow.
May I have
Kindly
my
not
lords-
release the matter, my lord. I need time in August. my lord.
Why do you want to
Because my lord, the
have this
hearing.
bench hold on to that matter?
My lord,
There's no guarantee how much time I will be able to devote to it. Then I will write a judgment.
Because it's a hearing matter, that is why I beseech you, lordship, my lord. Kindly,
No,
kindly not
tomorrow,
release.
no. I will list it. I will delist it. Yes.
May I have my lords kindly to mention a matter, my lord. This is a contempt application, my lord. Lordship's order is dated 16th of September 2022. My lord, the Director of Industries, my lord, Commerce and Finance Department was directed to, my lord, make the scheme, the industrial scheme, GST compliant within 16 weeks, which expired in January. We filed the contempt in February. I was only praying anytime convenient, my lord, if my lord next week or my lord thereafter, it can be, my lord, listed. For the first time, my lord, it has to be listed.
For the first time.
For the first time.
Yes, on 11th August.
Grateful, my lord.
Yes.
Lordship, may I permitted to mention one matter, Lordship? This is a matter regarding contempt application, Lordship. The matter is related to recovery of house rent allowance in the retirement benefits, Lordship. The petitioner is a senior citizen, Lordship. Lastly, Lordship, on 21st April, Lordship directed to serve the copy to the contender, which has been, Lordship, done.
Yes, on 25th August. Yes.
Lordship, may I permitted to mention one matter. Lordship, one contempt application. Lordship, the order has been passed. Lordship, 30th August 2018. Lordship, thereafter, Lordship, the contempt application has been filed. And Lordship, during the COVID period, it was not hard and it was out of list. And after that, it was mentioned. And your Lordship was pleased to fix this matter under the heading of contempt application. Lordship, but it was not hard.
No. What is the date of that order? When did I ask it to be listed?
Lordship, that time, Lordship.
Yes, come back with
Lordship,
dates.
kindly, Lordship.
No. Come back with dates. There's no kindness here. You have to come back with dates. If you're mentioning before the court, come back with dates. Yes.
Lordship, may I
Yes.
permit to mention one contempt application, Lordship. Lordship, order was passed 9th June 2022. Lordship directed the concerned authority to release the tender amount, which was completed by the petitioner, Lordship. But in spite of that,
What is the date of the order?
9th June 2022.
Yes, you mentioned in August. Yes.
Lordship, it was running in the list.
No. You mentioned in August. Yes.
May I have your lordship's kind leave to mention an assigned matter? My lordship was pleased to adjourn the matter in view of pendency of the transfer petition before the Hon'ble Supreme Court. Now the
Is
transfer.
this matter, Mr.
My
Mojumdar?
lord, I have brought the order for the lordship. So this is a matter, my lord, where the notification was issued prohibiting blending of certain edible oils. Lordship had heard the matter substantially. And now the transfer petitions have been dismissed by the Hon'ble Supreme Court. I brought that order.
Mr. Mojumdar, why are you saying now? They were dismissed on 15th of March.
Yes, my lord. I'm so sorry. I'm so sorry.
So what is the urgency now, Mr. Mojumdar?
My lord, I am praying if your lordship let it be listed in the month of August, subject to your lordship's kind.
It's a part
My lord,
matter.
it's an assigned.
Assigned matter.
Yes, madam. My lord, the business is totally stopped.
Assigned matter gulo kobe niche? 9th August.
Grateful,
Notice to the other side, please. Eta pherot diye do.
Great.
May I be permitted to mention, my lord, an assigned matter for inclusion in your lordship's list. This was last heard by your lordship on 17th of May. And my lord, this is a matter in which the Food Corporation of India had issued a tender subsequent to that the petitioner had deposited an earnest money deposit, my lord. All the affidavits have been exchanged and your lordship on the last occasion has called for a
Also an assigned matter. Why assigned?
written matter, my lord. Let it appear any day, my lord. I mentioned it.
No, don't disturb. Yes, last week of August. Yes, call on the list, please.
Commercial division matter. Item number 2, to be mentioned, Tata Motors Finance.
This matter, the lordship was being pleased to appoint a special officer, my lord.
Yes.
Lordship was being pleased to appoint a special officer to take possession of 3 of the assets which are parked in a parking yard at Hon'ble.
Yes, and they have released only one.
Only one receiver, I believe from the report, she was there for the entire day. She perhaps has to
almost beg to the yard owner, my lord, to release at least one. And the person, my learned friend's representative, I believe he has not tendered any assistance.
My lord, I appear for the award debtors.
And my
Yes.
lord,
My
there's
lord,
only-
in the receipt, sorry, yes.
there is only one small mistake, perhaps last order, your lordship has recorded that award holder will comply, my lord. We have complied with all your last line. We have complied. We
Yes,
have
yes,
paid the
that's right. Yes.
remuneration also. My lord, I
Yes.
am led by this.
My lord, so far as my lord, my conduct is concerned, my lord, in the receiver's report, there is no allegation against me. From the very inception, when this execution proceedings were taken out, my lord, I have always cooperated and always represented to the award holder that the vehicles can be taken possession of because we don't have any money.
No, but if you have any dues pending, then you have to settle those dues.
My lord, as per our instruction, there are no dues which are pending towards the yard owner. Now, my lord, it seems from the report that the yard owner has said that he has some claims against me. And my lord, that is the reason why he is holding back possession of the vehicles. My lord, he doesn't have a right. As far as my instruction is concerned, he doesn't have a right. He has no claim whatsoever. And even if he has any claim, he has to lodge that claim, initiate any legal proceeding against me, my lord.
Yes, yes, Mr.
My
Banerjee.
lord, the only one submission is, on the last occasion, the lordship has, my lord, clarified that this dispute.
This means use a microphone.
Yes, my lord, your lordship has clarified that this dispute between the yard owner and the judgment debtor, my lord, is of no consequence. The lordship has recorded that. My lord, on the submission made on behalf of the judgment debtor, that there is no dues. Now, my lord, the only compliance which is required is your lordship's order of 19th June.
So what is it that you want now?
My lord, within 3 days, they were supposed to hand over the vehicle to us as on 19th June. That is
No, but
exactly, my
Mr.
lord.
Dashgupta is saying that there is no resistance from his side. So then what happens then?
No allegation against me.
But if there is no resistance from their side, then they should, my lord, hand over the vehicle to us.
We are
There is
prepared.
no necessity for any special officer or, my lord, any receiver or any external assistance or an extension of arm from your lordship's court. This is as simple as that.
My lord, may I say this? My lord, apropos my learned senior friend's submission. My lord, there is a resistance. It is clear from the receiver's report. There is a resistance from the yard owner. We are not resisting from them taking possession of the vehicle. Well, if there is a resistance, well, the proper course is to take police assistance and go there and take possession of it. If in fact the police station, the jurisdictional police station was visited by all the parties concerned on the last day, it is reflected in the receiver's report. The
My lord,
police
with
did not.
deepest respect. My lord, they are supposed to hand over the vehicle to us.
Yes, this matter has needlessly made several rounds to the court on an insignificant point, on a point which should not have invited the court's intervention. Stop. The learned counsel appearing for the award debtor says that there is no resistance from the award debtor in handing over two of the remaining vehicles to the award holder, while learned counsel appearing for the award holder submits that the award holder submits that the learned receiver appointed by the court was unable to take possession of the two vehicles. Stop. Next. It is also the submission of counsel appearing for the award debtor that there are no dues pending with the yard owner, and therefore that cannot be made the reason for the award holder not being able to take possession of the two vehicles. Stop. Next. The dispute between the award debtor and the yard owner is not before the court and should not and cannot hence be a ground for non-compliance of the directions passed by this court. Stop. Next. Same paragraph. The petitioner/award holder will hence be permitted to take police help to take the two vehicles, to take possession of the two vehicles. Stop. Have you paid the receiver? Next, list this matter on, yes.
My lord, 2 weeks time, my lord.
list this matter on 31st July 2023.
One indulgence, I have been instructed that a direction is perhaps required on the superintendent of police.
No. No directions required. This is not a writ petition.
On the last occasion, it's minor correction in your lordship's order.
Yes. Daughter,
Last
order.
line should be award.
The order passed by the court on, the order dated 21st July 2023 should be corrected in the penultimate line to begin as quotation marks, the award debtor is expected ... in the meantime, close quotation marks, full stop. Next.
I'm grateful. Item numbers 2 to 7. 2 to 7. 2 to 6.
Yes,
Okay.
call on the next matter.
I'm grateful.
Act order. Next.
Item number 7, Kotak Mahindra Bank. Item number 7, Kotak Mahindra Bank.
Ma'am, my lord, this is for withdrawal of the case. The case has been settled between the parties.
Warrants of arrest? No. You're the advocate on record? Then?
I'm for Sinha and Company. Shesha Das is the advocate on record. Ma'am is on legs in court 38.
Yes, the advocate on record of the petitioner seeks to withdraw the execution case on the ground that the parties have settled out of court. Stop. EC 293 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated. Warrants of arrest shall stand discharged. Warrants of arrest, if any, shall stand discharged. Next.
Item number 8, Mrs. Power Make Projects.
Yes.
My lords, after the last date of hearing, I took instructions from
The
my
stamp,
client.
stamp act?
Yes, ma'am.
Yes.
My lords, I took instructions from my client, and what has transpired that after the issuance of the work order, the
Yes.
parties had actually entered into an agreement,
Yes.
which has also been duly stamped at that juncture only. My lords, I crave my lord's leave to bring on record the copy of the agreement. In fact, my lords, the client is also here today before my lords carrying the original agreement. My lords, I have served a copy on Mr. Das.
Have you done it by way of a supplementary affidavit?
Yes, my lord.
Yes.
My lords,
where
I'm
is the-
also carrying the original agreement with me, my lords, if my lords.
That's page 9.
My lords, it starts from page 9.
Yes, give me a copy of the original one, please. So this is between,
This is between the parties, my lords, Bail and my client, Powermake. My lords will see on the top of the agreement, contract agreement, the next line is Bharat Heavy Electricals Limited.
yes.
And my lords, in the next page also, once again, the name of the parties and their description has been
No,
provided.
where is your name?
My
Yes,
lords,
yes, name of contractor.
yes.
Where is the stamp?
My lord, stamp is at page 9, and if my lords are seeing the original, it is just before the engrossed paper my lords are seeing.
₹100.
Yes, my lords. My lords, for 100, my lords, in the notice inviting tender, my lords, there is a clause there. I'll show my lords at page 78, where it has been clearly mentioned that the agreement will be subsequently signed on a non-judicial paper of ₹100.
Yes, but it's insufficiently stamped, isn't it?
My lords, the stamp duty for
Then
such an agreement is ₹10.
Very well, you have to show me the schedule then to
Yes,
stamp it. Yes. Show me that it's sufficiently stamped.
My. Okay. My lord, schedule 1A.
1A.
1A, item number 5.
Agreement or memorandum of an agreement.
My
that
lords, my lords, E is the one.
one. Why, yes, E.
E, my lords.
Why is it in matters not otherwise provided for? That is the one you're pointing out.
My lords, because my lords, there is no specific provision in relation to an agreement of this nature or an
No,
arbitration.
what is the
agreement.
nature?
My lords, the nature of the agreement is supply of services and goods. That is the nature
What
of the
kind of
agreement.
services and goods?
My lords, it is actually a thermal plant
Yes.
where I have been appointed as a contractor to provide certain kinds of services for the operation and commissioning of the plant.
Yes. So basically you were to commission the plant.
My lords,
Yes. And that is not provided for under Schedule 1A.
that is not provided for. So therefore, in fact, I would also want to bring my lord's attention.
So you're saying that then you would come under rupees, so anything above 10 would be fine.
My lord.
Yes.
My lord can also see page 78
Of
volume 1 of my petition 444. My lord, there is no dispute today.
Yes. Yes, which clause?
My lord, 22.28.1.
Yes, so you're saying that 100 rupees is fine because of this clause.
My lord. My lord, there is another thing. I am just apprehending one more contention from
Yes,
Mr.
yes, of
Das.
course.
Therefore, I want to address that. If my lords will kindly come to the contract agreement which has been signed by the parties.
Yes. Yes.
My lord, page 11. My lord will remember on the last occasion, the submission were made that the arbitration clause as provided in the notice inviting tender was identically placed in the work order. And my lords, what has happened in this agreement that all the provisions of the notice inviting tender, the work order and any other document issued by the respondent in relation to completion of this project has been incorporated in this contract agreement by way of reference.
So 7.5. Which clause is that?
My lord, 7.5. 7.5. My lord will kindly come to page 11,
Yes.
para 15.
Yes.
It is clearly understood by and between the parties that in the event of any conflict between the letter of, sorry, my lord, 16. The following documents, 16.2 is the notice inviting tender, which is there in my petition at page 20.
Yes.
Then my lords, the next page, page 12, 16.18. This is the letter of intent, which is also there in my petition at page 17. And then the work order, my lord, which is at point 16.20. The contention was on the last day, my lord, that this work order is not stamped.
Work
Where is
order
the
is which page of your petition?
239.
Yes.
And my lord will now come to the last line after the end of 16.29, and others, if any, shall also form part of the contract agreement.
And the arbitration clause is in the work order.
My lord, it is in the work order and also in the notice inviting tender. My lords, for my lord's convenience, I have also quoted the clause in my supplementary affidavit once again. The general conditions of contract, which is a part of the notice inviting tender.
So this was a contract agreement which actually bound the parties.
My lord.
And what did you rely on on the last occasion?
My lords, on the last occasion, I was relying upon the notice inviting tender and the work order.
And the arbitration clauses were?
My lords, at
39.
both the places, my lords, first I'll show the general conditions contained in the notice inviting tender. My lords, page 75 of my, page 75, volume 1 of my petition.
That's the NIT.
That's the NIT.
Yes, and the other one is 239.
Well, 272.
272.
Volume 2.
That is the work order.
My lord, that is it.
And you're saying that both these documents form part of that contract?
My lord, I'm grateful.
And 100 rupees stamp is fine because of that particular clause in the NIT or in the contract?
My lord, two things, in the NIT and the Stamp Act, my lord. That is 5E of Schedule 1A.
And NIT, that clause is at 78. Yes, Mr. Das.
Lordship, this stamped contract which has been provided before your lordship does not itself contain any arbitration clause.
Yes.
So their case is section 7.5. Kindly takes the specific clause relied upon, where it says the following documents.
Yes.
Then there's a list of 29 documents which includes the NIT and the work order. Then it says, and others, if any,
Yes.
shall form part of the contract agreement.
Yes.
So this is a general reference to all these contracts. There's no specific reference to the arbitration clause. Kindly take section 7.5 once, and then place judgment.
And this is what, a section 11, Ms.
Yes,
Dalmia?
Yes, this is section 11. My lords will remember that there was a section 14, and thereafter again we are before my lords under section 11.
Take section 7.5.
Seven five.
Yes, ma'am.
Yes.
The reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing. I'll pause here for a moment. The legislature could have stopped here. Then it says, and the reference is such as to make that arbitration clause part of the contract. So, my lord, when this latter part comes, it has been interpreted that a general reference to a document containing an arbitration clause will not do. There must be some specific reference to the arbitration clause in the document. Let me, my lord, place two judgments of the Honorable Supreme Court to support my submissions.
So what do you think, I will look at the judgments. What do you think, Mr. Das, would have been a correct reference in consonance with 7.5?
Arbitration clause contained in clause number such and such of the NIT is also incorporated as part of this document. There should be some specific, or the dispute resolution mechanism as provided in the work order and the NIT will be incorporated in this contract.
So just not a reference to the document simplicity, but specific reference to the arbitration clause.
That is the requirement for section 7.5, which has been laid down by the Honorable Supreme Court.
Yes.
One of the first judgment is 2009, 7 Supreme Court cases, 696. My lord, comes to paragraph 14. wording of section 7(5) of the Act makes it clear that a mere reference to a document would not have the effect of making an arbitration clause from that document a part of the contract. The reference to the document in the contract should be such that shows the intention to incorporate the arbitration clause contained in the document into the contract. If the legislative intent was to import an arbitration clause from another document merely on reference to such document in the contract, subsection 5 would not contain the significant later part which reads, and the reference is such as to make that arbitration clause part of the contract, but would have stopped with the first part which reads, the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing. Section 7(5) therefore requires a conscious acceptance of the arbitration clause from another document by the parties as a part of their contract. Before such arbitration clause could be read as a part of the contract between the parties. But the Act does not contain any indication or guidelines as to the conditions to be fulfilled before a reference to a document in a contract can be construed as a reference incorporating an arbitration clause contained in such document into the contract. In the absence of such statutory guidelines, the normal rules of construction of contracts will have to be followed. After that, my lord, from paras 16 to paras 23, the discussion is there how these contracts have to be interpreted, and paras 24, my lord, summarizes the position as per the Supreme Court. The scope and intent of section 7(5) of the Act may therefore be summarized thus. An arbitration clause in another document would get incorporated into a contract by reference if the following conditions are fulfilled. The contract should contain a clear reference to the document containing arbitration clause. The reference to the other document should clearly indicate an intention to incorporate the arbitration clause into the contract. The arbitration clause should be appropriate, that is capable of application in respect of the disputes under the contract, and should not be repugnant to any terms of the contract. When the parties enter into a contract making a general reference to another contract, such general reference would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. The arbitration clause from another contract can be incorporated into the contract where such reference is made only by a specific reference to arbitration clause. Well, two other exceptions are carved out. Where the contract, 4 and 5, I'm reading. I'll read the entire clause. Where the contract provides that the standard form of terms and conditions of an independent trade or professional institution, as for example, the standard terms and conditions of a
Where
trade.
are you reading from?
My lord, clause 4.
4. Yes.
Sorry, my lord, I have skipped 3.
Yes.
I'll read 3 also.
No, that's all right. Yes.
That is not very relevant. So
Yes. 4.
where the contract provides that the standard form of terms and conditions of an independent trade or professional institution, as for example, the standard terms and conditions of a trade association or architects association, will bind them or apply to the contract. Such standard form of terms and conditions, including any provision for arbitration in such standard terms and conditions, shall be deemed to be incorporated by reference. Sometimes the contract may also say that the parties are familiar with those terms and conditions, or that the parties have read and understood the said terms and conditions. Now, my lord, 5, where the contract between the parties stipulates that the conditions of contract of one of the parties to the contract shall form a part of their contract, as for example, the general conditions of contract of the government, where the government is a party. The arbitration clause forming part of such general conditions of contract will apply to the contract between the parties. Now, your lordship kindly considers, I am not the government. I have a public sector undertaking, but I am a separate, my lord, company where the government holds a large share. I also have public shareholders. I'm listed on the stock exchange. My tenders are not standard format. These are for specific thermal power projects. Each have different parameters, etc. And my lord, so far as the general rules are concerned, nowhere in that document I have stated that the arbitration clause contained in those documents will be incorporated. There is another clause, my lord, in the kindly comes to page 11 of the supplementary affidavit, just before clause 16. It is clearly understood by and between the parties that in the event of any conflict between the letter of intent and other documents governing this agreement, the provisions in the letter of intent shall prevail. So it's not my intent that all these other documents shall be incorporated lock, stock and barrel. And the letter of intent, my lord, they have annexed it. It does not contain any arbitration clause. It says if there's a conflict between the letter of intent and other documents, letter of intent will prevail. Then it says these documents generally and any other documents will be part of this contract. There is no specific intent anywhere in this to incorporate the arbitration clause. Now, my lord, this ratio applies more so while interpreting a fiscal statute. Because at the end of the day, your lordship, because of this general reference, your lordship still has to look at the NIT and the work order.
Yes.
To send the parties to arbitration under section 11. And my lord, the injunction in section 35 of the Stamp Act as applicable to the state of West Bengal very clearly says it cannot be received into evidence, it cannot be looked into, it cannot be acted upon.
No, but what about schedule 1A, 5?
My lord, this first we have to assume that this stamping of this agreement means an automatic stamping of the work order and the contract. Here, because there is no general reference to the arbitration clause, there is no incorporation by reference. The lordship has to still look at that document of the work order, which is unstamped. And so far as Article 5 is concerned, my lord, kindly sees they have relied on subpara E.
Yes.
If relating to matters not otherwise provided for, except matters relating to checks, ₹10. So this is a residuary clause, my lord. So when they are entering into this agreement, this may be applicable. But when they are, and it says my lord, when they are entering into the work order and they are entering into the NIT, they still have to stamp those documents. Just by stating a general reference to that document, they cannot avoid the fiscal responsibility of this document. It is stated that if 5 agreements are forming part of the same transaction, then all 5, it is sufficient if only one of those agreements are stamped. But that will defeat, because the stamp duty is not on the underlying transaction. It is on the instrument. If there are separate instruments, just by saying that instrument generally will form part of this instrument, does not mean that the other instrument can be received into evidence automatically. So each of these instruments have to be separately stamped with
So you're saying just not the contract only, but the work order as well as the NIT?
Not NIT, the work order, because work order, NIT is the offer.
Yes.
Acceptance is the work order. That is when the concluded contract came into being with the work order.
Yes.
After that, this agreement has been entered into, which generally refers to the work order. Firstly, my lord, this document does not specifically refer to the arbitration clause. So we cannot say the arbitration clause itself is embedded in this document. Secondly, if we, just by this general reference, if you have to look into that previous work order, then your lordship will also have to consider whether that work order is stamped or not. There is no exemption here. There is, my lord, one exemption, very specific, for several instruments for forming part of the same transaction, but that is section 4 of the Indian Stamp Act. But that is very specific. Several instruments used in single transaction of sale, mortgage or settlement.
Yes.
Where in the case of any sale, mortgage or settlement, several instruments are employed for completing the transaction. The principal instrument only shall be chargeable with the duty described in Schedule 1 for the conveyance, mortgage or settlement. And each of the other instruments shall be chargeable with a duty of ₹1 instead of the duty, if any, prescribed for it in that schedule. So, my lord, even here, this is of course not a transaction of sale, mortgage or settlement.
Yes.
Where the exemption is there. Even there, my lord, if you have a principal document which is stamped duly, even then the other instruments have to be stamped with ₹1. And this is a document which is unstamped. So, my lord, there is no exemption. My lord, one more judgment which reiterates the position in MR Engineers, which I have cited. Let me just, my lord, quickly place that. My same provision. Both these cases, a general reference was not allowed. This is 2018. 4 Supreme Court cases, 281. So the relevant paragraphs are 14, 15, and 16 relies on MR Engine and says the same thing. A general reference will not do. There should be specific reference to the arbitration clause.
Very well.
I'm ready.
Yes.
That was the first judgment upon which Mr. Das has relied upon.
Yes.
That has been considered in another Supreme Court judgment, my lord. Placing my reliance. My lords, to put it simply, in this case, what had happened, there was a scheme in which an arbitration clause was there.
Yes.
Pursuant thereto, several sales orders were issued. Now then,
You're talking about this one, Giriraj Garg?
My lord.
Yes.
Well, several disputes arose between the parties subsequently. Now, the question was that whether there is an subsisting arbitration agreement between the parties or not, and
Yes.
whether the arbitration clause as contained in the scheme can be incorporated by way of reference to the sales orders issued subsequently.
Very well. Tell me which paragraph you want to rely
My
on.
lords, I am relying upon paragraph 6 and 7. That is at page 11.
Yes.
If I may read.
Yes.
In the instant case, the learned single judge in the impugned order had erroneously taken the view that an arbitration clause would not stand incorporated in the individual sales orders entered into by respondent number 2 coal company and the appellant. The individual sales order emanate out of a 2007 scheme. The sales orders specifically state that they would be governed by the guidelines, circulars, office orders, notices, instructions, relevant law, etc., issued from time to time by Coal India Limited or Bharat Coking Coal Limited, etc. As a consequence, the arbitration clause, that is clause 11.12 in the 2007 scheme, would stand incorporated in the sales order issued thereunder. And after considering the judgment which Mr. Das has just cited, my lords, will find that judgment.
Yes, 5.10.
5.10. My lords, I am also placing my reliance on Roman 4.
Yes, standard form contracts.
My lord. And my lord, one paragraph, I'll just for the sake of completion, I will also read paragraph 7, that is at page 11. Clause 7 in the sales order falls under a single contract case, where the arbitration clause is contained in a standard form document, that is the 2007 scheme, to which there is a reference in the individual sales order issued by respondent to coal company. Well, as the other point which has been taken over here, that the LOI, that in case there is any conflict between the contract agreement and the LOI, the provisions of LOI will prevail. But my lords, the question which needs my lord's kind attention is, where is the conflict?
Did you say that, Mr. Das?
There is a provision in the.
There is a provision. Yes.
But my lords, today, there is no conflict. It is not a case, my lords, when two different kind of procedure has been established in two separate documents vis-a-vis the dispute settlement clause.
Yes.
My lords, one last thing, I would want to place my reliance on a judgment, my lords. I do not have a copy handy with me, my lords, but it's in.
That's all right. As long as Mr. Das can have the opportunity to.
My lords, I'll not place that.
No. Why? You can always place it. Mr. Das doesn't need a reference anyway. Yes, you can place it and then you can give it to Mr. Das. Yes.
My lords, it's an unreported judgment. My lords, in this, what had happened, multiple agreements were signed between two parties. And again, the issue which came up was that in the main agreement where the arbitration clause is there, it was not incorporated in a subsequent agreement, which is a lease deed, which was a stamped agreement. So the conflict was the document where the arbitration agreement is not stamped.
That's fine. What? Just give me a copy of that decision with the which paragraph are you relying on?
My lord, I am relying upon para 10 and 11.
10 and 11. Saying what? Same thing as Giriraj Garg.
same thing as Giriraj Garg, that it need not be there incorporated in each and every document. And if one
that also considers MR.
that does not consider MR, my lords. And my lords, the other thing is that what it says that if there are 5 documents in relation to one contract and all are interrelated, it's been said that they are interrelated and incorporated generally by way of reference. No specific clauses have been put in, and one is stamped and the other is not stamped, wherein the arbitration clause is contained. Then also, my lords, the Section 7 application was allowed.
Very well. Ms. Dalmia, you do this, please. Give me I'm keeping this matter tomorrow.
My lord.
Just for tomorrow or day after, just for both of you to give me 1 page of your points, 2 points. One is a stamp act. The other is the incorporation by reference.
Very
2
well.
points. All right. And with a copy of this decision so that Mr. Das can just distinguish it.
I will share the copy with Mr. Das during the course of the day.
Give him the citation. It will be fine, or the copy, whatever. Yes.
On the other judgment, may I distinguish it?
Mr. Das,
Tomorrow.
day after tomorrow.
Yeah. Great.
Learned counsel appearing for the petitioner and the respondent have made their submissions on primarily 2 points. Stop. First, comma, the alleged insufficiency of the stamp, and second, whether the arbitration clause in the work order has been incorporated in the contract entered into between the parties. On what date is it? In 2015? What date?
Date of the contract. And once the date of the contract which is annexed to the
15th.
supplementary agreement.
15th October.
15th October 2015. Stop. Next, list this matter on the learned counsel appearing for the petitioner has filed. Now, the supplementary affidavit on behalf of the petitioner is taken on record. Stop. Next, list this matter on 26 July 2023 for counsel appearing for the respondent to distinguish the judgments.
Grateful, Your Lordship.
My lords, I'm returning the original agreement to the client, my lord.
Yes, yes, I don't need.
Right, grateful, my lords.
একটা লাইন লিখে দাও যেখানে বললাম supplementary affidavit has been filed, ওখানে লিখে দাও the original agreement of 25th October 2015 has also been placed before the court. Stop. Yes. Call on the next matter, please.
Item number 9.
My lords,
What is this? Same.
my lords. We'll
Same.
keep it for 26th only, my lords.
This is what? This
My
is
lords,
the,
here, my lords, again, it's
no, what is the application under?
Section 11.
11. Very well. List this matter along with Onno Epita Deda on 26th.
There's only one additional issue here. They want to club the 2 arbitrations, which is not possible. That will be my submission on.
Club the 2 arbitrations.
The 2 arbitrations in item number 8 and 9, they want to club it together before one arbit, which is not permissible under.
Very well. List this matter along with AP blank on 26 July 2023.
My lords, in this also I filed another supplementary, my lords, same.
The
contents.
supplementary affidavit of the petitioner is taken on record.
Very
Next.
well, grateful, my lords.
Grateful.
Item number 10, Mrs. Koilas Traders.
May it please your lordship. Lordship, I appear on behalf of the petitioners in this. This is my section 11 application. Before my lord applies my lord's mind.
Yes.
Lord, I am extremely embarrassed to come before my lord and pray for.
What are you saying? I can't understand.
My lord, I am extremely embarrassed to come before my lord and pray for leave to withdraw the application and file the same afresh on the self-same cause of action, as it is my duty to bring notice to my lord that there are.
You're the respondent.
No.
You're not supposed to be standing there.
Lord, he's my advocate on record. There are a few annexures has inadvertently gone in, which should not have gone in, and a few material annexures has not been numbered correctly. So I am praying before my lord for leave to file this.
What is this under? Section?
Section 11, my lord.
And you have served this on the
Lord,
respondent.
I have also informed the respondent that a few annexures I am also pursuant to me obtaining leave. I shall.
You're the counsel.
Yes, my lord, I am.
Learned counsel appearing for the petitioner seeks to withdraw the application on the ground that important annexures have been missed out. Stop. Next, AP 478 of 2023 is dismissed as withdrawn. Stop. Interim orders, if any, shall stand vacated. Stop. Leave to file afresh. Next. The petitioner shall communicate this order on the respondent. Next.
Item number 11,
This
who is
my
submitted
application under section 11 of the Arbitration Conciliation Act. My lord, we have served on the respondents by email, but the physical copy has, however, not, it's come back as insufficient address. This is the affidavit of service, my lord, arising out of a delivery contract of coal. There was short supply.
Why does the cause title seem familiar?
My lord, because in the other matter, it was Rashmi Metallics versus the same respondent. Here, my lord, it's a separate company versus the same respondent. It arises out of the same, it's a similar contract.
This is
delivery
that
contract.
the other matter that review is pending.
Yes, my lord, the review is pending.
Very well. So what do you want to do now, Mr.
Lord, we have
Ghosh?
served them on email, but the physical copy has not been served because it's come back as address insufficient. It's on the same respondent. My lord, we have also received an email from them, a letter communicating, my lord, this is in responses after filing of the section 11, my lord. They have accepted the existence of the arbitration clause by not denying it, but they have said that there are no disputes.
Mr. Ghosh, the respondent has to be here.
Yes, my lord. I'll come back, my lord, with a
Yes.
fresh service.
Yes, learned counsel appearing with the petitioner submits that the respondent could not be served and seeks time to attempt fresh service. Stop. List this matter on when?
Lord, 1 week hence.
List this matter on 31st July 2023 as paid for.
I'm ready.
Next.
Item number 12 and 13, Ayubur Rahman and other.
In this matter, Mr. Priyanka Saha appear for the petition. I am praying for 7 days time to go through
Can't
the
understand a single word what you're saying, microphone.
Mr. Priyanka Saha appear for the petitioner.
Yes.
Due to some difficulty, I pray for 7 days time because the entire arbitral proceeding record handed over by the department to go through the same kindly allow me 7 days.
So this is your application?
Yes.
Who has handed over the application to you?
Department as per your lordship direction, last.
This is your application?
No,
No,
my
Lordship, their application.
the arbitral proceedings record,
Lordship, the arbitrator filed his.
Is it 34?
Yes, sir, 34 and
36,
as well as
36.
36. Lordship, I am praying for a short passover. If the matter has been taken, I am praying for a short passover.
Yes, tomorrow. List this matter tomorrow.
Tomorrow, difficulty, Mr. Priyanka.
What has happened to Mr. Shaha? Why are you seeking 7 days time on his ground?
He will not come to court tomorrow and day after tomorrow.
Very well. List this matter on 27th July 2023 as paid for. Next.
Item number 14,
14, my lord, I am for the petitioner.
Meena Agarwal.
I'm led by Mr. Surojit Nath Mitra, my lord. May I pray for a short passover, my lord?
What is it? It's a 34.
No, this is an application that has been filed, my lord, and your lordship was pleased to grant an order of stay in a 36-2 proceeding, my lord. Order is at page 9, my lord. This is an application for extension of bank time to file the bank guarantee, my lord.
You're for the?
This is
My lord, I'm for the respondent, my lord. The award holder respondent, my lord.
It's an innocuous prayer, my lord. We have, the petitioner tried to file the bank guarantee within the time period, but due to some fault on the part of the bank, it was not accepted by the registry, my lord. So I'm praying for 2 weeks or 1 week's time so that I can file it, the bank guarantee.
Very well. 12:30 is all right
12:30.
with you?
Yes, my lord. Come back to 12:30.
Grateful, my
Next.
Grateful.
Item number 15, the New India Assurance.
My lord, in this matter, Mr. Sumit Talukdar is appearing, my lord, due to personal difficulty, he has not come. I'm just praying for not today. my
And the
lord.
matter is similar to the previous one, my lord. I appear for the petitioner, my lord. I am seeking 1 week.
What is similar to the
Lord,
previous
we-
one?
there was a direction to furnish bank guarantee to secure part of.
Yes, list this matter tomorrow as prayed for. Next.
Grateful, man. Item number 16, Mrs. Ugro Capital.
May it please your lordship. I'm appearing on behalf of the petitioner in this matter. This is under section 9 of the Arbitration and Conciliation Act with respect to Miller, an agreement under which rupees 5 crore odd was Miller lent in advance to the respondent. Then Miller has been order passed by this honorable court imposing injunction on the operation of the bank account and Miller disclosure of the details of the book debts towards which there are independent agreements because those book debts were Miller the hypothecated assets. Repeatedly, this honorable court Miller has passed directions upon the respondents to disclose those book debts, which is Miller recorded initially in the order of May and thereafter by a lordship in subsequent orders. In the meantime, the respondent Miller filed an application seeking recalling of 2 orders passed by the erstwhile determination. The lordship was pleased to release this matter. The matter came up before Miller, the honorable court who had passed, honorable judge who had passed the order. And Miller, there the respondent has withdrawn those applications. At this stage, Miller, your lordship is now hearing the arbitration.
So
petition.
as of now, there are no review applications
No.
pending.
So, Miller, my only humble submission is
So it's a section 9.
it's a section 9.
So what is the order you want?
Miller, there is an order of injunction, but Miller, under the
Injunction
agreement,
from
injunction
what?
on their bank account, so
Freezing
that
their bank account.
freezing their bank account.
So what else do you want?
Miller, the necessity over here is that under the agreement, which is the loan agreement, Miller, there is a hypothecation of the book debts. For that, Miller, there is a separate agreement which appears at page 102 of this arbitration petition.
So
Miller, they
how
have
is
been-
that agreement connected to the
Yes, yes,
to
it is
the-
connected, Miller, because that is the only asset or the series of assets, the book debts.
I
to
asked
which,
you what is the other order you want?
Miller, I want Miller disclose. They are supposed to disclose the book debts. Miller,
Yes.
they have not been disclosing the book debts. So, Miller, if one last opportunity can be given to them to disclose their book debts, after this, Miller, I shall be pressing for
And
attachment
if
before
they
judgment.
disclose, then what is the advantage which you gain?
Miller, I come to know about the status of my hypothecated assets. Because,
Assets? What
yes.
kind of hypothecated assets?
Miller, book debts and receivables. Miller,
Like what?
Miller, money. I have given loan, they
Yes.
have again given it to other people.
Yes, yes.
My lord, I have been instructed, my lord, orally, your lordship, that all these book dates are under RBI's scrutiny, your lordship. So this is I have instructed.
RBI scrutiny?
Yes,
What
your
does that
lordship.
mean?
My lord, this scrutiny is going on since January, your lordship, that have been instructed, my lord, that all the documents are lying with the RBI, your lordship. Since your lordship kindly give some time for that, otherwise.
Yes,
my-
file an affidavit by Thursday. Saying this, bringing
My
this on record.
My lord.
All right. Learned counsel appearing for the petitioner complains
Oh.
that despite several directions passed by the court, the respondent, what is this, award debtor?
No,
Or
this is a
pre-reference?
pre-reference.
The respondent is refusing to disclose.
Well, the respondents, several respondents.
The respondents are refusing to disclose the
The lordship sees the book debts hypothecated with the petitioner.
which order is that?
3rd May 2023. And thereafter, your lordship's order of June 15, 2023.
Refusing to disclose the third May doesn't say anything about the book debts.
Miller, the
Which order says that?
first paragraph, where I get Miller an order in terms of prayer B. And if your lordship now comes to your
First
lordship's
paragraph says prayer B.
yes, prayer
Yes.
B,
So prayer
whereby-
B is what?
whereby the respondent
Yes,
were directed to give details of
Refusing to disclose the book debts hypothecated with the petitioner. Stop. Council refers to an order passed by a coordinate bench on 3rd May 2023 and submits that that although the petitioner is presently enjoying an order of injunction on a injunction with regard to freezing of the respondent's accounts, comma, the petitioner requires further orders in terms of the particulars of the hypothecated assets. Stop. Next, learned counsel appearing for the respondent submits that the book debts are presently being scrutinized by the Reserve Bank of India and hence cannot be produced in court and hence cannot be disclosed to the petitioner. Stop. Next, the respondent's apostrophe. The respondent's stand is required to be brought on record by way of an affidavit. Stop. The affidavit should be filed by 27 July 2023. List this matter on 28 July 2023.
Lordship, my client is residing from Jaipur, Your Lordship. I need some time to bring a affidavit from their home.
Should be filed by 31st July 2023. List this matter on 1st August 2023.
Deeply grateful, Lordship.
Item number 17 and 18, Cobalco Construction Equipment. Lordship, this.
Lordship, I'm praying for a short passover because
I can't understand what you're saying.
Lordship, I'm praying for a short passover. I'm being led by Mr. Shatru Banerjee. He's in court number 38.
You are finished, Mr.
Lordship,
Gupta?
it was only to file a written notes.
Very well, tomorrow. Yes, adjournment is prayed for on behalf of counsel appearing for the petitioner. List this matter tomorrow. Next.
Item number 19, Probir Kumar Jana.
My lord, I appear on behalf of the petitioners, my lord. On the last occasion, my lord, I had prayed before your lordship to kindly grant me a leave to amend the cause title of this application, my lord. Because the spelling of the respondent, my lord, is different from what it appears in the cause title, my lord, due to the reason of which the service could not be completed upon them. As a result thereof, my lord had passed an order, my lord, by which my lord had directed to amend the cause title. Unfortunately, that could not be amended because, my lord, the word leave was not mentioned in the order, my lord. That's word leave to amend the cause title, my lord. That was not.
Which order are you referring to?
My lord, I'm referring to the order dated 17 July 2023. That was last Monday, my lord. So when, my lord, the learned advocate on record went to the department to carry out the amendment, my lord.
Yes, learned counsel appearing for the petitioner submits that the leave granted to the petitioner to amend the cause title by way of the order dated 17 July 2023 could not be given effect to, since the order does not specifically mention granting of such leave. Stop. Next. The petitioner is granted leave to amend the cause title as prayed for. Stop. The department is to take necessary steps.
My lord, may I beseech your lordship to kindly grant me one more leave, my lord, that is to seek the amendment of the computerized records. Because if that is also not done, then I will have to effect a fresh letter upon the registrar original site.
Yes, department will do that. If you have any problem, then come back.
I'm extremely grateful, my lord.
List this matter on when do you want to come back?
My lord, 2 weeks, my lord, because after the amendment, I will have to effect the
List
fresh
this matter
service,
after
my lord.
2 weeks as prayed for fresh service before the returnable date. Next.
I'm extremely grateful, my lord.
Before the matter is taken up. Next.
Item number 20, Ugro Capital.
But I'm appearing for the petitioner, my lord. It's a post-award section 9 application. My lord, the service upon respondent number 4 and 5 is still not complete because I'll be praying for an order of security, my lord. There's a mortgage property which is there. So I was humbly praying, my lord, if I could come back, my lord, after a week. But perhaps the service will be completed within the next 2 days.
List this matter after a week as prayed for. Stop service in the meantime. Next.
Grateful.
21, Sunil Kumar Dubey.
Lordship, I'm appearing in this matter. I've got a change, my lord.
And understand what your microphone, please.
I'm appearing for the respondent bank.
Kindly grant me leave to file the wakalatnama.
Can you not understand that I'm asking you to use the microphone? How will you do the matter if you can't understand the court?
Kindly grant me leave to file the wakalatnama as well as the
You're the
affidavit
petitioner.
of service.
What is this matter, Mr.?
Affidavit of service in the department, my lord. In
But
course
it's a
of tomorrow.
section 9 application, my lord, where they are praying for an order, my lord, of injunction against one of the property which was financed by the respondent, my lord. But from the document, I will indicate, my lord, that we have, like, there were two facilities.
Very well. Wakalatnama,
After tomorrow, my lord. No problem.
yes, list this matter on 27 July 2023.
27 July, lordship.
Wakalatnama in the meantime. Next.
Grateful. 27 July.
22 IDFC First Bank Limited.
This is my section 9 application, my lord, the affidavit of service, my lord, and supplementary affidavit, my lord. My lord, brief facts of the case is
Affidavit of service.
last occasion they have appeared, my lord.
Yes. Why have you filed a supplementary affidavit?
My lord, to bring on record the account statement, my lord.
Whose account statement?
No, the bank's account statement, my lord.
Have you served this on the respondents?
My lord,
The supplementary affidavit?
my lord, I am not aware of that because
Very well. When do you want to come back?
well, tomorrow, my lord.
List this matter tomorrow, since learned counsel appearing for the petitioner is not sure whether the supplementary affidavit has been served on the respondents. Stop. Next.
Much obliged. My lord,
I-
this is
I
also
number
my section 9
23,
application,
IDFC
the
First Bank.
supplementary affidavit, I am not sure.
What are you saying?
My lord, this is my section 9 application.
Yes, so wait for the cause title to be called on. Yes.
I-
Call, Bol.
Item number 23 IDFC First Bank Limited.
My lord, this is my section 9 application, similar grounds, my lord, we had filed a supplementary affidavit, my lord.
Supplementary affidavit.
Yes, my lord, I am filing it.
Same order. Should the লিখে রাখো, the petitioner's supplementary affidavit is taken on record. দুটোতেই একই হবে. Next.
Much obliged, my lord.
24 Rohan
IPF
Builders.
Appear for the respondent in this matter.
I'm for the petitioner.
I'm praying for a short passover, my lord, to file the notes only. Today, lordship has fixed to file the notes only, my
So
lord.
why if you praying for a Passover?
My lord, just my lord, notes is not here, my lord. It's
Your Lordship, we ask for the direction of,
Yes, our notes is ready.
I'm submitting before your Lordship
Yes,
the written notes.
Learned counsel appearing for the respondent seeks an adjournment on the ground that the note is not before the court as yet. Stop. List this matter tomorrow.
Your Lordship, kindly record that we are filing the written notes. The
I
petition.
will record what I want to. All right. List this matter tomorrow. Next.
25 MAP Mines and Minerals.
Your Lordship, I'm appearing for the petitioner. This is an application under section 29(4) of the Arbitration and Conciliation Act.
29?
29 subsection 4 of the Arbitration.
29(4)?
29A subsection 4 of the Arbitration and Conciliation Act, Your Lordship. I'm praying for an adjournment because I'm being led by Mr. Shomo Roy Chaudhary and he is out of station. So kindly, I would request Your Lordship to grant me an adjournment.
Tomorrow, Mr. Medora?
I can come back tomorrow, but I would like to file an opposition to this matter to bring on record certain documents, correspondence, and minutes of the arbitral tribunal.
So
hearing.
you're opposing
I'm
the
opposing.
extension?
I'm opposing.
Very well. The petitioner seeks an extension of the arbitrator's mandate under section 29A within brackets 4 of the 1996 Act. Stop. Next, learned counsel appearing for the respondent opposes the extension and seeks to file an affidavit to bring on record certain facts and minutes, capital M, of the sittings. Stop. Affidavit in opposition by?
2 weeks, my lord.
By 31st July 2023. Reply within?
1 week.
Reply by 4th August 2023. Stop list this matter on 7th August 2023.
May I, your lordship, be permitted to submit the affidavit of service?
The affidavit of service is taken on record. Mr.
On
Medora,
8th August instead of 7th.
8th August. Korda.
Lordship was saying something.
No. Have you, are you representing all of the respondents?
Yes,
Or the,
yes.
Yes. Next.
I'm grateful.
Grateful, your lordship.
Item number 26, Board of Major Port Authority.
My lord, I appear for the respondents. my lord.
This is our application, last time Mr. Dotto argued, Kishore Dotto argued the matter, we have filed our.
Mr. Chaudhary?
Yes.
My lord, 19(2), my lord, section
I
19.
had one query actually.
Lord, Mr. Chaudhary is on his way, my lord. If my lord
27.
Dotto.
wishes, my lord, Mr. Chaudhary
Lordship,
will
kindly
grant
pass
a
it
passover for 10 minutes, my lord. He's on his way already, my lord.
Very well, 12 o'clock.
Much obliged. my lord.
Because I have a question for him. Just tell
My
him what
lord.
the question is.
My lord,
Then he'll be ready.
my lord.
He had mentioned a point about the section 34 for the purposes of section 36(2) of the 1996 Act being like a plaint.
My lord,
Just that point.
my lord.
All right.
I'll indicate. Next.
Item number 28, Mrs. Cole Construction.
My application under section 34, my lord. My lord, here, my lord, lordship was hearing us, my lord, with regard to, my lord, an arbitrator being appointed. My lord, admittedly, his, my lord, termination was on, my lord, the expiry of, my lord, the 1 year. My lord, my clients did not give consent to the extension for another 6 months.
You're the petitioner.
I am the petitioner here under section 34. He still continued, and ultimately, my lord, he holds in the award that, my lord, the period for limitation of the COVID would apply. But, my lord, I am not on that. I am on the issue, my lord, when a party under 29A, my lord, 3 does not agree, the question has to come before the court for extension. My lord, suo moto, the arbitral tribunal cannot, because he becomes functus officio and his mandate gets terminated. Whether he's entitled to the limitation period or not.
So it's a 14 or a 34?
No, it's a 34. He's already passed an award holding this, my lord, in his favor, saying that this period he has got the jurisdiction to extend. My, my lord, submission is that in terms of the act, my lord, once, my lord, under 39A3, I do not agree, then 39A4 applies. But whether that period is to be extended under the, my lord, special limitation provisions which came after the, my lord, notifications and judgment of the Supreme Court, that is within the domain and jurisdiction of the Honorable Court. The tribunal cannot extend it, my lord. So I say, my lord, this award is wholly without jurisdiction.
And how is the Supreme Court extension coming in? How is that
Supreme
relevant?
Court, my lord, he has relied upon the Supreme Court by saying that this period of limitation will apply because the COVID has come into being. Therefore, I am extending that period and it is within my jurisdiction to pass an award.
No, so that Supreme Court order extended the 29A1, the 1 year period.
Yes, my lord, that has been extended. That had been extended, my lord, till 28th of February 2022. Now, my lord, here, my lord, it's a peculiar case. That also I'll argue, but that's on merits, my lord, is that during the COVID period, regularly he has held, my lord, sessions, and every
Mr.
month
Banerjee,
3
ask
sessions.
your junior to take his seat, please.
My lord, every month he has, my lord, held 3 sessions during the COVID period. So therefore, my lord, there is no question of limitation coming in. My lord, it cannot be that I am holding sessions during the COVID period and then again take the, my lord, point of limitation just to extend my mandate. That is not possible. So, my lord, firstly is that he didn't have jurisdiction even to extend, because that once I, my lord, under 39 capital A3, my lord, say no to his extension, it's the court's domain. It's the court's jurisdiction.
I'm just asking you for the purposes of 29A1.
Yes, my lord.
Is whether the period of 1 year
Yes.
from the date of completion of pleadings, that itself was extended by the Supreme Court order.
Well, it says 29A. It does not, my lord, says 1, 3 or 4, my lord. It says 29A applications. That is the language in the judgment also. So, my lord, I believe, my lord, Supreme Court thought of the entirety of 29A.
No, that's fine. Supreme Court is not,
Lord, it
we
did not
can't expect,
define.
we can't expect that Supreme Court
He
will
say,
go on
it
to
says
the.
29A. That's
29A.
language about
Yes, so that would
judgments.
apply to all these.
Yes, my lord, if I may read, section 23, subsection 4 and 29A. That is all. my
So
lord.
that is basically that the mandate shall not terminate.
Yes,
That was the sense.
yes. But,
Yes.
but the issue is that, my lord, mandate terminates, or, my lord, he will get the, my lord, advantage of the limitation period under the COVID. My lord, that will now be decided by the court, because 39A3, I have pointed out that your mandate has terminated during the period of arbitration, and I've said I'm not giving you consent. But after that, he could not have
So,
proceeded.
Mr. Banerjee, since it's a 34, under which subsection are you coming under?
My lord,
This argument.
my lord, it is against the public policy because it is against the law. The law does not permit it, my lord. The award, my lord, is perverse on the face of it because it is contrary to the law.
So 34 2B,
Yes,
III.
yes, my lord. Completely contrary to the
Wait,
law.
who was there on the other side?
My lord,
Mr.
Mr. Banerjee, Mr. Ki Banerjee, Shiv Shankar Banerjee
Yes,
was
yes.
appearing. Lordship had asked us to give a, my lord, dates only, my lord, so that, my lord, Lordship can, my lord, is able to understand from which date the pleadings got completed and, my lord, the limitations start. My lord, we had prepared it, my lord, maybe five.
Yes.
It was directed to them also, my lord, so. My lord, if your lordship, my lord, only takes, my lord, the list of dates, my lord, the order of appointment was 13 January 2020.
Yes.
My lord, he called for the first reference day or the first sitting on 10th of February 2020. Then, my lord, the second sitting was February 24th, 2020. This was, my lord, close to the COVID starting. Then, my lord, arbitration sitting could not be held due to COVID pandemic from March 2020 to 5th September 2020. Then 6th September onwards, my lord, pleadings were extended. So, my lord, participation in the arbitration proceedings started. Although, my lord, there was still pandemic on.
No. So when does the first year, the 1 year start?
My lord, that is what I'm coming, my lord. Kindly sees, my lord, the pleadings which got completed, my lord, on the statement of defense being filed on 20th of October 2020, my lord, item 7.
Yes.
So from this time, the 1 year would start and it would end on 19th of October 2021. Ever pleading with minutes page. Now, my lord, kindly.
Yes, at this point of time, the time stopped because of the Supreme Court order.
Now, my lord, kindly takes page 126 of my application. That is the minutes, which is very relevant.
Yes, so it can't be 19th October 2021. That's what I'm saying, Mr. Banerjee, because the Supreme Court order is already in place on 20th October 2020.
Yes, my lord, I'm coming to that only, my lord. Is that, my lord, 20th of 1 year would, my lord, expire on 19th of October 2021, according to the act. Now, my lord, what happens, my lord? My lord, kindly takes, my lord, page 120, 125. That's the minute, my lord. My lord, arbitration was proceeding. My lord, there was no, my lord, break in the arbitration in usual course, my lord, which has taken place in other matters. Every month, 3 sittings. During the COVID also.
Mr. Banerjee, come to the law.
Yes. Now, my lord, kindly
one
comes.
year is supposed to end under 29A1 on 19th October 2021.
Yes. Now, my lord, kindly comes to page 125.
Yes.
Volume 2.
Yes.
Volume 2. First page of volume 2.
First page.
First page of volume 2.
My lord, this is the minute of the 32nd sitting on 10th of January 2022.
Yes.
So, my lord, 10th of January 2022 is as it is, my lord, post 1 year. Much beyond 1 year.
Got the benefit of the Supreme Court order.
My lord, that, my lord, won't be why I say, my lord, that benefit he'll get from the court. That's what, my lord, the point is. My lord, why I say this? Because he will get, probably he might get, my lord. With all due respect to my lord, the arbitrator, he might have got it. But my lord, he
No,
would
no,
have.
no, Mr. Banerjee. Court, he will have to get it from under 29A4.
Yes.
Here I am saying that 29A1, that period itself got extended.
No, it won't be, my lord. Why I say, my lord, then my lord 29A3 becomes redundant because my lord, then no consent is required. It will automatically
no,
get
no.
extended.
No, no, no. I've passed a judgment very recently, I think 2 weeks back. The dates, the benefit, you will have to calculate from whenever that order ended. I think it was 28th February 2022, Supreme Court's order. You will have to calculate the number of days before 15th March 2020, the number of days before 15th March 2020, and calculate the number of days after 28th February 2022.
Yes.
And see when that 1 year is expiring.
So, my lord, that I agree, my lord, with the limitation period. My lord, I am not on that. I am saying, my lord, in a situation like this, kindly comes to the minutes of 125, my lord.
Yes.
My lord, kindly sees, my lord, what has taken place. My lord, last paragraph. Upon receiving information of the day's sitting, the respondent's learned counsel such and such informed the tribunal that the time to publish the award has expired and no arbitration sitting can be held by this tribunal on 10th of January 2022 or thereafter. Upon receipt of such information, this tribunal brought it to the notice of the advocate of the respondent that parties, this is very important, my lord, parties by consent can always extend the time for the award to be published. So, my lord, this is the premise that, my lord, the learned arbitrator is proceeding. In response to the said observation of the tribunal, the respondent's counsel intimated this tribunal that the respondent is not willing to give consent of such extension. However, the tribunal brought it to the notice of the learned counsel that her submission need to be recorded in the day's meeting and requested her to be present in the day's meeting. In spite of intimation being sent by such and such, my lord, WhatsApp and email also link have been sent. No one on behalf of the respondent has been today virtually.
So Ms. Shroff is the respondent's counsel?
Yes, she was appearing before the, my lord, tribunal.
Yes.
Now, my lord, kindly sees Mr. Banerjee's submission. Learned counsel on behalf of the claimant submits that in the instant case, time to make and publish the award has not expired, considering the indications given in the Honorable Supreme Court's judgment, pass suo motu. These judgment in computing the period of limitation, the period from 15th March till 2nd October stands excluded. That was, my lord, prior to, my lord, the final judgment coming out. The balance period of limitation remaining from 15th March 2020, if any, shall become available with effect from 3rd of October 2021. In the instant case, pleadings of the parties have been completed on 19 December 2020. This is wrong because it can't be 19 December because it should be, my lord, from the date of the defense being filed. My lord, not the rejoinder. My lord, learned tribunal has taken the date of the rejoinder or sir rejoinder, which is not the date. It should be 20th of October 2020. Be that as it may, my lord, in the ordinary course, the award ought to have been published within 12 months from 9 December, which is 8 December 2021. It is the submission of Mr. Banerjee that considering the aforesaid judgment in the instant case period between 10 December to 2nd October 2021 is to be excluded. In the instant case, the balance period that remains to be added from today is roughly 8 months, 26 days. The period from 3rd October 2021 till January 2022 is exhausted from 12 months. Which takes us to 2nd October 2022. Having considered the aforesaid judgments passed by the Honorable Supreme Court of India and submissions of Mr. Banerjee, this tribunal is also of the opinion that there is enough time for the award to be published and the submissions made on behalf of the respondents' time to publish the award as expired is not being accepted by this tribunal. In as much as Mrs. Such and such is not present in the days in spite of having been notified, the application filed by the respondent could not have been.
What is the application?
Well, that was the application, my lord, that the time to, my lord, make and publish the award has expired. The mandate has terminated.
Yes.
Next sitting is on such and such. An account of Mrs. Shroff, respondent such and such is being cancelled. However, my lord, then the fees part and all is there, and then it is also recorded that the respondent is either to place its application under 12 and 13 at the next sitting, or in the event of the respondent does not press the said application, the cross-examination of the
So
12
this
and
is the
13 was
application.
pressed. Yes.
This was the application.
It was pressed and it was, my lord, refused by him. Now, my lord, the question is that even if I go by my learned friend's submissions, Then, my lord, 2nd October 2022 is the last day. That's paragraph 4, my lord, last line. Now, my lord, the award has been passed on, my lord, 14th of February 2023. Now, my lord, kindly takes 29A once, my lord.
This is the date of the award.
Date of the award, my lord, lordship will find in my list of date, 14th of February 2023, the last day, my lord.
Yes.
14th of February 2023.
Yes.
The award is the award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of the pleadings under subsection 4 of section 23, which is, my lord, statement of defense. Now, my lord, kindly sees 3, my lord. My lord, may I read from 2 itself? If the award is made within a period of 6 months from the date of the arbitral tribunal enters upon, the arbitral tribunal shall be entitled to receive additional fees. The parties may by consent extend the period specified in subsection 1. That is what I am on, my lord. 1, my lord, automatically does not get extended. This is my case, my lord.
Absolutely. Mr. Banerjee, does not get extended if there had been no order of the Supreme Court as on that date. If there is an order of the since there is an order of the Supreme Court, and if I remember correctly, one of the orders specifically mentioned 29A.
29A, that
Yes.
is there.
So if that is the case, then the period under 29A1 would automatically get extended till that 28th February 2022, at least would have the benefit. The tribunal would have the benefit till 28th February 2022, and then you add whatever number of days balance.
My lord, kindly, my lord, 3 kindly takes 4 after that, my lord. That is why I'm saying why it won't get, my lord, if I object. It won't get, my lord. The court can always do it. The parties.
No. Mr. Banerjee, your objection will come not under 29A1. It will come under 29A3 for the 6 months additional.
Yes. But
And
that is
I am
exact-
saying that even before the 6 months additional, and you have the right, any party will have the right to object. I am saying that you don't have to progress to 29A3. 29A1, that one year period gets extended because of the pendency of the Supreme Court order.
My lord, there, in this case, my lord, this particular case, there is another issue which is very important.
Yes.
There is another issue which is very important. Why I am showing, my lord, 29A3 and 4 is that, my lord, kindly sees, my lord, even if I go, my lord, what is, my lord, falling from my lord, then admittedly, my lord, on my lord, let us take, my lord, that he can extend. He has got the jurisdiction to extend, my lord, the limitation.
No, I'm not saying that. I'm saying that he just got the benefit, fortunately, from the Supreme Court order. I'm not saying that he has the power to extend, not at all. The arbitrator does not have the power to extend. Every time, not every time, if a party does not consent under 29A3, and if the 29A1 and 3, those periods have expired, parties have to come to the court.
Exactly.
There is no.
My lord, that is exactly what I am on, my lord. My lord, I am saying that perhaps this arbitral tribunal would have got, my lord, why should I say would have definitely got the advantage of this limitation period of the Supreme Court. But why this tribunal will not get, my lord, that is exactly what I am on. I am never saying that the limitation period of the Supreme Court judgment will not apply. It would apply. But, my lord, it would apply, my lord, by, my lord, this honorable court extending it. The arbitral tribunal would not have in this particular facts of the case. He would have got, my lord, had this period been extended prior to expiry of the 1 year. That also this arbitral tribunal has not done. My lord, kindly sees his time, my lord, to file, my lord, the 1 year extends on 19th of October 2021. So, my lord, he should have ideally, my lord, my lord, I bow down, my lord, that it would apply that to a Supreme Court judgment. It should have been before that he should have extended it. Once, my lord, 19th February comes into play, 19th October 2021, my lord, he becomes functus officio. My lord, to apply even a law, the court has to assume jurisdiction. My lord, somebody may have a remedy under the law, but my lord, if I may give an example, I have a claim, my lord. But, my lord, if I come to the court after the period of limitation, My lord, my claim will not be sustained by the court, although the court may have jurisdiction to entertain the my lord, dispute, but it cannot because the limitation period has come into play. Just like that, this judgment would apply to the honorable, my lord, the learned tribunal. But my lord, when it has got the jurisdiction with him, my lord, not after the jurisdiction itself has
Mr.
expired.
Banerjee, that jurisdiction ended. That jurisdiction of the arbitrator ended on 28th February 2022. After that, whatever time he has taken, if there are no balance, if there are no balance days to be added, after that, if you have objected to under 29A3 for the additional extension of 6 months, the arbitrator loses that jurisdiction to extend. But till the Supreme Court order subsists, and that is till 28th February 2022, the arbitrator can extend his jurisdiction and does not need to come to the court.
Perhaps, my lord, that is exactly what I am trying to show, my lord. In this case, he would have to, because, my lord, after even expiry and after this minutes, which is, my lord, of 10th of January 2022, my lord, here also in this minutes, my lord, he has not extended the time. He has just observed the submissions of both the parties. He extends the time, my lord, when he passes the final award on, my lord, 14th of February 2023. This is wholly without jurisdiction. I would have understood, my lord, on 10th of January also.
Very well. Mr. Banerjee, from what you have handed up, and I
have
yet
only,
to
my
see
lord, the
Mr.
list of dates.
the other Mr. Banerjee, Mr. Shivshankar Banerjee. It's not clear about the extension of the mandate with regard to the Supreme Court order. The benefit is not, obviously you will not show it because you're saying that he didn't have the mandate, but that Mr. Banerjee will have to show you.
Lord,
And you show it to me. No, you show it to, you're not here. You should have been here. You show it to me day after tomorrow or on Thursday. All right.
Lordship, I have handed over one short list of dates and two more.
Yes, heard learned counsel appearing for the petitioner, who has placed, who submits that the arbitrator, that the learned arbitrator became functus officio after 19th of October 2021, which was 1 year from the date of filing of the statement of defense. Stop. Council places the minutes. Council places the minutes of the tribunal of 10th January 2022 to submit that the arbitrator himself extended the mandate, which the arbitrator could not have done in view of section 29A within brackets 4 of the Act.
May I say something? Well, that minutes even has not, he has not extended.
Very
The
well.
final award. he has
Council submits that in any event, the minutes do not reflect, capital M, the minutes do not reflect any such extension, and that the extension became apparent only from the award, impugned award, dated 14th February 2023. Stop. List this matter on 26th July 2023 to hear learned counsel appearing for the respondent.
27th, Lordship. 26th, I have another matter before your Lordship that might take some time. Lordship.
So what?
I might not be ready in both the two matters, Lordship. Kindly 1 day more time, Lordship.
27th July 2023 as prayed for.
Grateful.
Passed over matter, please.
Pass over matter at 12 p.m. Item number 26 and 27, Board of Major Port Authority.
Our notes are there.
This is regarding, my lord, the.
I remember. I have some.
Yes, my lord.
I just have one. I told.
Yes, my lord. I have
Mr.
been
Mukherjee.
informed, Lordship wants to.
Yes, just that point, Mr. Chaudhary, that you had mentioned, you had drawn an analogy.
I had given an analogy regarding filing of suits.
Yes.
That, my lord, I had said that, my lord, in the event a suit is instituted in our original side where a clause 12 leave is envisaged,
Yes.
then my lord, mere filing of the suit itself, let us say the last day of limitation,
Yes.
would not suffice, because we may get a CS number, but then if clause 12 leave is not granted, it will not be a valid suit in the records.
Yes.
Technically, it will be there, but it will not be a valid suit in the records. And if in such a suit, any interlocutory application is taken out, my lord, the defendant can always come and say that if the parent proceeding is not valid, then the subsequent proceeding or the subsidiary proceedings will not be valid. So, my lord, over here, my lord, the issue is between the expression filing or filed as used in 36(2) vis-a-vis, my lord, the word entertain, which is there in section 19 of the MSME Act.
Yes.
Now, my lord, kindly also note another component called made. My lord, section 34 says, 34(1) I read out, recourse to a court against an arbitral award may be made only by an application. And my lord, if lordship takes section 34(3), an application for setting aside may not be made after 3 months have lapsed from the date for which party. And then the proviso reads, proviso is again introducing the term entertain, provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the said period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter.
Yes.
Well, if we combine the two, well, a filing envisaged under 36(2) has to be validly made under section 34. This is my first submission.
Yes.
And my lord, if it is an MSME, then my lord, it can be made under section 34 only if section 19 is complied with by virtue of section 24 of the Act, because of the overriding provision. It is as if by virtue of the overriding provision, the section 19 is incorporating an additional term for an application to be validly made under section 34. Otherwise, my lord, the interpretation which my learned friend is giving, I had pointed out that anomaly also, and I put it in my note, that it is theoretically possible that I will file a section 34.
But the 34(3) argument.
Yes. I will file a section 34 after say 6 months. Filing is there. If my learned friend's interpretation is taken to its logical conclusion, he can come up with a 36(3) and say, look, it is filed. You don't have to see whether it is valid or invalid. It is filed. So I am putting in the money. Kindly stay the award. So theoretically, an award can be stayed in a 36(3) if my learned friend's interpretation is taken to its logical conclusion without the parent proceedings existing in the eye of law. That, my lord, would lead to absurdity, and any interpretation which leads to absurdity, my lord, should be discarded. And that is the.
And your other point was the 24 point, section 24, overriding effect.
Because section 24 is saying that the provisions of sections 15 to 23 shall have effect notwithstanding anything inconsistent therewith. Now, assuming for a moment that section 34 can be made otherwise without any deposit, by assume, my lord, in all cases where MSME is not involved, section 34 is merely to be made within the time parameters specified, 3 months and the additional proviso 30 days. It can be made. But over here, my lord, to make it valid, my lord, section 9 has to be read in, or my lord, section 19, I'm sorry, section 19 has to be read into 34.
No, that's all right. So that was a
Yes.
No, I can't say a Freudian slip, because section 9 also uses the word entertain.
Entertain.
9(3).
Entertain. So, my lord, over here, my lord, filing has to be, my lord, valid. And my lord, entertaining is a question, my lord, where lordship's discretion is coming in. My lord, that is why, my lord, lordship will find even in 34, the proviso is saying may entertain. First part is saying may not be made if it is not within 3 months. And proviso is saying may entertain within a further period of 30 days, but not thereafter. So even after 90 or rather 3 months, lordship may not entertain if sufficient cause is not there. But if it crosses the further threshold of 1 month or 30 days, further period of 30 days, Lord, that discretion for entertaining or not, even if my lord wants to entertain, the law will not permit my lord to entertain. And my lord, if I borrow this provision for the sake of interpreting section 19, it is saying shall not entertain unless 75% deposit. And my lord, this buttresses, because my lord, kindly see section 19 in 2006 only, my lord, much prior to all the Supreme Court judgments coming in, my lord, the proviso is saying, moment the money is deposited, the supplier can, my lord, apply and get the money withdrawn subject to such conditions.
That is a proviso.
That's the proviso.
Yes.
And well, this incorporation has now been made so far as section 36(3) has come, my lord. We find now the Supreme Court judgments are there that, my lord, we are making application before your lordships, 100% or, my lord, whatever, furnishing a bank guarantee, withdrawing the amount. This, my lord, was there from 2006 itself, the proviso. The permission granted to the supplier to withdraw the money 75% on such terms and conditions. And, my lord, my submission was that here, my lord, the 36(3) is, my lord, not maintainable because the parent 34 is stillborn. That's the expression, my lord,
Yes.
stillborn.
Yes.
And after that hurdle is crossed, my lord, when he comes to 36(3), my lord, my submission would be, lordship would then consider that in by virtue of 36(3), my lord, whether he can be called upon to deposit the balance 25. That will be the for stay, for granting stay. As of now, my lord, there is
First, the maintainability has
it's
to
a
be asked.
maintainability. The point is no 34, therefore 36(3), there cannot be a 36(3). As on date, there is no section 34 in the eye of law. Those are.
Yes, that's all. Mr. Dotto, you have to.
I have made this clear, my lord, in my written notes.
Yes.
Please have a look to, my lord, the page number 3. With the second last paragraph at page 3.
Yes.
There's a typographical error. The respondent has contended that section 34 application is like a plaint in a suit with section, well, this should be 36, not 34.
Yes.
With section 36 application is in the nature of an application in such suit. But I've given my response as per the language of section 34 and 36 of the Act. Section 36 application cannot be held to be an application filed in a section 34 proceeding. As per this honorable court's judicial interpretation, they are separate proceedings. The High Court allots separate EP numbers for the applications under section 34 and 36, though both concerns the same award. Section 36 application is not allotted any GE number to make it a general application in a section 34. My lord, as your lordships know, my lord, a suit, but my learned friend says that section 34 is in the nature of a plaint.
Yes.
But as your lordships know, my lord, that a suit is instituted by filing a plaint. Thereafter, whatever applications are filed, my lord, these are applications filed in a pending suit. Similarly, in other proceedings, say for in the writ jurisdiction.
Yes.
In the writ jurisdiction, my lord, a writ petition is the institution of a writ proceeding. Over in a suit, it is the plaint. In the writ, it is the writ petition. It's not a writ application. In the writ petition, once it becomes sub judice before the court, we take out applications, which are all interlocutory in nature. But going by the language of section 34 qua section 36, my lord, one cannot get an impression that section 34 is the parent proceeding and section 36 is an application in the parent proceeding. But this is my submission. Number one, and number two, my lord, on the entertainability point, but we have my lord, according to me, my lord, that situation has not come because I have not pressed my section 34 as yet. But when I press my section 34, my lord, the question of entertainment of the section 34 would come, and then, my lord, whether 75% is a prerequisite or not, your lordship would decide that.
Entertainment as in whose? Mr. Dotto? Entertainment of section 34?
My lord, the submission of my learned friend, my lord, again, by today's submission.
That was an aside. I've understood your
Yes.
Yes.
But again, my lord, on the limitation aspect, please note, my lord, the difference of the expressions used by the the legislature. On the entertainment aspect, post expiry of 90 days, the legislature uses the expression entertainment. Whereas before that, it is the filing part. we have not reached to a stage where, my lord, I am requesting the court or inviting the court to entertain an application for setting aside of an award. I am today, my lord, invoking the court's jurisdiction for a prayer that you please stay the award without condition. Now, my lord, that's a different thing for your lordship's consideration. But we are not at the entertainment stage today. Therefore, section 19 of the Act cannot be put into operation today, number one. And number two, section 34 may or may not be valid for very many reasons, but it cannot be said to be a stillborn at the section 36 stage. But finally, my lord may not entertain the section 34.
Yes.
No, these are my submissions.
Learned Counsel have made their submissions and already handed up their notes, their respective notes. Stop. List this matter on 31st July 2023 under the heading for judgment.
I'm grateful.
And 1 minute, Mr. Dotto and Mr. Chaudhary, what is 27? This is 26.
27 is the 34.
It's a parent 34, section 34 application.
The only difference is
You
he
should
calls
say
it
valid, Mr. Chaudhary. Mr. Dotto does not like the word parent. You should say valid. Yes.
He likes it to be orphan.
It is made clear that the maintainability issue has been raised only in AP 252 of 2023, which is the application for stay of the award. Stop. What is the other one? AP
179. 179.
179 of 2023 is the application for setting aside of the award, which will be heard, which will be taken up for hearing subject to the decision on the maintainability of AP 252 of 2023.
I'm grateful.
Yes, call on the next matter, please.
Item number 29, Mrs. Binoy Trading.
In this matter,
I can't hear you.
leave to file the application which I filed before the court below for release of the vehicle. I am
Yeah, I have a
submitting.
copy, my lord.
Yes, give your friend a copy, please, Mr. Chakraborty.
Because our endeavor only to show to your lordship that in this application before city civil court, he neither has challenged the jurisdiction of the city civil court, but he has accepted
But
the.
we have not initiated any proceeding
no.
under the Arbitration Act before the.
Yes,
city
yes, he
court.
has.
No.
This is
We
the
have-
proceeding.
Very well, please, both of you. Yes, let me see the application, please.
You have paid for dismissal of the miscase and paid for release of the vehicle in their miscase, miscellaneous case.
I'm led by Mr. Manager.
Have you got a copy of the application? Yes. Yes, what do you have to say, Mr. Banerjee?
Paragraph 14, page 4 of the application, Madam. And the order which was passed in this particular application is also, my lord, recorded at page 20 of the application. This is a separate application.
In connection with their proceeding, I have paid for dismissal and paid for release of my vehicle on discharging the receiver. We have not approached the civil court.
Wait,
for-
that's all. And
only
have you?
one
Yes.
last submission, my lord. This application, my lord, can be treated as one under section 9, 2A Because this also talks about preservation, my lord, of the property, which is the subject matter of
No,
the
no, no.
arbitration.
That
Or
point is
my lord,
nothing.
at least two.
The only point which you have is a pecuniary jurisdiction. Yes.
Yes, pecuniary jurisdiction and this, my lord, to be treated as a
My-
bar
my
under section
submission
42.
is that my commercial court act did not.
Mr. Chakraborty, you will have to wait for the other side to finish, please. What is this? Every time I tell you the same thing, try to remember. Yes.
Sorry, my lord, in a similar matter between the same parties, my lord, that is AP number 289 of 2023. We have filed notes, my lord. My submission would be same if your lordship so wishes. I can file similar
Yes,
notes on this.
no.
I am again repeating.
That is
Not
not
required.
fixed.
What is the, what is the AP, that the other one?
AP 289 of 2023. My lord, it
Yes,
has, it has
the-
been fixed on
the-
2nd August for orders.
The submissions made on behalf of the parties in the present case is similar to AP
289 of 2023.
289 AP 289 of 2023, which is which has been made returnable on 2nd August 2023. Stop. List this matter on that date.
One submission. my lord. And my lord, my friend has, my lord, taken.
I remember your points, please.
The Commercial Court Act is, my lord, city civil court has not been.
Very
empowered
well.
to
Call on the next matter, please.
I'm deeply obliged.
Item number 30, Afsar Sheikh.
Lordship, I'm praying for a short passover. Mr. Abhidipta Tarafdar is appearing in this matter. I'm praying for a short passover.
My application under section 34 appearing
Yes,
after
at,
service.
sorry, what is this?
Section 34 application appearing after service. Probably they will seek direction to file affidavit, my lord.
Lordship, we will hear you.
What is
Lordship,
it
I'm
that you
praying
want?
for a short passover.
No. Affidavits? How much time do you want?
Lordship, 2 weeks.
Thank you. You have prayed for setting aside and stay in the same application. Can you do that? Under section 36(2)?
No, probably not. But in the peculiar circumstances that was prayed for, my lord, anyhow, my lord, we'll file a separate application. Second, we are
What do
not
you mean?
pressing-
It's not the order of court, it's a statute, 36(2).
My lord, we are not pressing this.
Yes, the petitioner has prayed both for stay as well as setting aside of the award of an award dated 24th January 2022. Stop. This this kind of rolled up prayer, rolled up hyphen prayer is no longer permissible under the amended section 36 within brackets 2 of the 1996 Act. Stop. The petitioner shall hence only pray for setting aside. The petitioner the petitioner is permitted to only pray for setting aside of the impugned award. Stop. Next. Next, affidavit in opposition within
2 weeks, Lord.
2 weeks. Reply within
2 weeks.
2 weeks thereafter. List this matter after 4 weeks.
Great, Lord.
Thirty-one, Anirban Mitro.
Your lordship, this is a section
My lord,
34
appear on
application.
behalf of the respondent. My lord, I haven't received the copy yet.
What is this 34?
Yes, your lordship, I believe my advocate on record is not there today. He has some family problems, but I believe it has been served.
Very well. You can't believe when your advocate
Yes,
on
your
record is not
lordship,
here, Mr. Sinha.
Your lordship, may it be kept for tomorrow?
Yes, you're the counsel or the
advocate on record.
since the advocate on record of the respondent submits that she has not received a copy of the application, list this matter tomorrow as prayed.
Your lordship, may I just also give her a copy right now? Then maybe it's a easier process. We may record it. I'm
Yes.
giving her a copy here.
A copy of the application has been handed over in court today. Next.
Item number 32. Passover matter. Item number 14, Meena Agarwal.
For the respondent and for the petitioner, my lord, this is an application that has been taken out for formal application for praying for an extension to file the bank guarantee, my lord. Your Lordship, on 14th of June 2023 was pleased to state.
Are you objecting to it?
Yes, my lord, I'm objecting to the last day. Well, kindly takes the order, my lord, once, my lord. Well, the order was passed on 14/6/2023, my lord. We'll find the order at page 9 of the application, my lord. Lord,
Yes, what was done on that date?
my lord, on the order, my lord, the award was stayed. With the condition, my lord, they are going to give the bank guarantee for 1.35 crores. And my lord, also there was a say that we couldn't satisfy that service was done because my lord, we didn't have the copy, my lord, whether to show the service was done by the honorable, the learned arbitrator, my lord.
Service of what?
The service of the award, my lord. Kindly, my lord, takes, my lord, to page 11, my lord. The petitioner by later date such and such would also serve a corroborating facts of non-service of the impugned order of the award in any way. Lord, there, my lord, we couldn't show, my lord, that point of time that the award was served
Very
upon.
well. So what is the extension you want now?
My lord, only one other thing, my lord.
Presently, my lord.
What they have done the last date of the 3rd week, my lord, they have given the letter, my lord. The bank guarantee was taken on the last date, my lord. They waited for more than 2 weeks, or rather, one of the entire week of the 3
So
weeks.
1.35 crores by way of bank guarantee you have not given.
It's all, it is in my hand now. The original copy is in my.
Very well. Do it in the course of the day then. All right.
My lord,
But
may
my
we have a
lord,
liberty, my lord? Why, my lord? My lord, now, my lord, we have a letter from the learned arbitrator to show that they were served, my lord.
That's the 34 point.
Lord,
Yes,
only one indulgence, my lord, because the registry, because your lordship is directing to file the bank guarantee in course of the day. So I, without the server copy of the order, my lord.
yes, এটাকে lunch পাঠিয়ে দেবে।
Grateful.
Learned counsel appearing for the petitioner seeks extension of time to comply with the direction passed by this court on 14 June 2023, whereby the petitioner / award debtor was directed to pay rupees 1.35 crores by way of a bank guarantee to be furnished to the registrar original side within 3 weeks from date. Stop. The 3 weeks expired on
5th of July 2020.
The 3 weeks expired on 5th July 2023. And the present application has been filed on 19 July 2023. Stop. Next. The petitioner shall hence furnish the bank guarantee with the registrar original side of this court in the course of the day. Stop. AP 341 of 2023 was disposed of, had been disposed of by the order dated 14 June 2023.
Grateful.
Next. Yes, GA1 of 2023 is disposed of in terms of the above. Next.
Grateful, my lord.
Item number 32. This is Ketan Constructions.
But I appear for the respondent, my lord.
It's my application.
Or I'll also take that point of maintainability with regard to the stamp act, my lord.
Mr.
Court
Banerjee,
fees.
you care to elaborate on what the objection
My
is?
lord, I am, yes, my lord, it is with regard to that 2006 Amendment Act which has come in of the West Bengal Stamp Act, my lord.
Schedule 1A.
Yes, which says, my lord, it has to be 5,000 rupees. My lord, the court fees have to be 5,000 rupees. I'm sure, my lord, my learned friend has not paid that. So, my lord, it's not maintainable.
So you don't know how much he's paid. You just want to take the objection.
130 rupees. I know that is what is being taken now for all court fees.
And that is pending before the appeal court.
It's not pending. The my lord, Advocate General has been called to give the date on which the act has come into, my lord, being, my lord. That is all.
And it's item number 2.
It is item number 2, but today, my lord, there is no appellate side list at all. It would come up tomorrow only.
Yes, Mr. Vedora.
I'll have to consider this point, but so far as this application is concerned, other than this point of stamp, my lord, 2 points, my lord. One is, my lord, that's a delay of 28 days in filing this application, beyond 90, but within 120.
Filing application of 34.
34. Beyond 90 days, but within 120 days.
Yes.
And my lord, my primary ground of challenge is unilateral appointment of arbitrator.
Very well. Where have you given the paragraph for the
So
delay?
far as the delay is concerned, my lord, paragraph 5 at page 9.
My lord, that delay also, my lord, will come into play because the high courts and supreme courts have held that, my lord, if the stamp duty is not paid on the date of the filing, my lord, the limitation will not stop. So perhaps today, my lord, if my lordship is with me, if I succeed, then my lord, he doesn't have a right of 34 even, because his delay, I think, is of 2-3 days, my lord. 2 days. So that will expire, my lord. I'll have an advantage of that also. That this point is now decided.
So, Mr. Banerjee, what? You want me to wait for the appeal court?
But
Division bench?
I have no other option because I've tried in the West Bengal list, my lord, of the, my lord, West Bengal government, my lord, Gazette office also they went, but my lord, there are certain acts which they don't have the notification. Only, my lord, the Advocate General can provide us, my lord. I have also asked Mr. Sinha, who is the advocate on record for the, my lord, government, my lord, of West Bengal. He has also, my lord, he's also seeking, my lord, instructions, my lord, so that this can be solved, my lord.
No, so give me a reasonable period of time. I can't make Mr.
I understand,
Medora,
may it
or
be,
for
my
that
lord,
matter, any petitioner wait.
Lordship has kept the other matter. Lordship has kept the other matter, I think, on 26th or 28th. Lordship can keep this on 28th, my lord. Lordship pleases.
Other matter means what? Which
But
one
the
is
other
that?
matter also, I've taken the point, several other matters, that is on 26th, my lord.
Yes, learned counsel appearing for the respondent seeks to take a preliminary objection on the insufficient stamp paid by the petitioner at the time of filing of the application under section 34 of the 1996 Act. Stop. Counsel submits that the issue is before the division bench and prays that the matter be taken up on 26th July 2023, when similar other matters are also to be listed. On which day similar other matters are also to be listed. Stop. Next list is matter on 26th is all right, Mr. Medora?
Grateful.
On 26th July 2023.
Grateful, my lord.
Grateful.
Next 4 matters will perhaps be similar orders.
Up till
36.
Aki order ko dako matter ko dako.
33.
So they are between the same parties.
The same parties, my lord, different awards.
No, not different opponents, same parties.
Same parties, different awards, mother. Awards.
Same arbitrator, different awards.
Act order kore daw to.
34, 35, 36.
Grateful.
Yes.
Thirty-seven, concrete developers.
Mr. Banerjee was amidst his submission, so I'll continue you.
Yes.
On the last occasion, the point that was being made
Microphone, please.
on the last occasion, I apologize.
Yes.
The point that was being made was relating to diminution. 24(5) issue had been addressed.
Yes.
That 24(5) perhaps does not apply to the facts of the instant case. And the case was covered by 22 Roman numeral 5 of the LLP agreement.
Yes.
I'll just dovetail that agreement, that contention in very brief. Thereafter, Mr. Banerjee has stopped by showing the supplementary affidavit filed by the respondent in the original arbitration proceeding, making further disclosure pertaining to further sales of flats. So I'll just commence from that juncture.
Yes.
Your Lordship will recall, on the last occasion, it was shown that initially disclosure of only 2 flats were made apropos the ad interim order passed in the 3rd sitting.
Yes.
Thereafter, we took an exception. We said that that is not the correct disclosure, correct state of affairs. Thereafter, supplementary was filed in our AR, in our affidavit in reply. We had taken that position. Apropos that, a supplementary affidavit had been filed.
Yes.
In the supplementary, they clarified that, okay, due to inadvertence, there has been a mistake. Mr. Banerjee had showed that paragraph. And instead of 2, 3 flats were disclosed as having been sold post demise of the deceased partner, who is the predecessor in interest insofar as I'm concerned. I'm his son, the claimant. Now, before I embark upon the exception that I took, once again showing that that disclosure was incorrect, which was subsequently admitted and corroborated by them in their statement of defense, I just want to point out, indicate.
So that is with regard to the number of flats.
Number of flats.
Unsold flats.
Unsold flats. Initially, they said only 2 flats have been sold. We took an exception, 3. Then ultimately, I'll show you, Lordship, that it ultimately transpired that the entire unsold inventory had been liquidated in course of the proceeding. And that is the aspect of diminution. And the funds that had accrued, that stood adjusted. We had also taken that point in our affidavit in reply. We had furnished the bank statement that had been taken note of by the arbitrator in the 5th minutes of the 5th sitting dated 19th of May 2022 at page 764, 767. It had been taken note of that these are my submissions, that as and when the revenue came in, it was disbursed purportedly to creditors, which upon us pointing out that it was perhaps not creditors, but the promoters, they clarify or promoters themselves were the creditors in respect of loans of specific tenure and term. Yeah, it had been placed. Now, insofar as that supplementary affidavit is concerned,
yes,
in the supplementary affidavit, it was stated that 3 flats have been sold. Now, to that, we took out an exception. That exception starts at page 726B at volume 5. There we stated at para 5 that this is not the correct position. And we furnished details and particulars to the extent I could have, because I'm an outsider today. My induction has been stalled.
Yes.
Although 22.5 does not envisage a precondition to my induction was stalled upon a red herring that without making payment of the losses, you cannot be inducted. Now, that is yet another point that had been argued.
And that is not provided for in the partnership deed.
Partnership deed was placed, but partnership deed, let's kindly take up the partnership deed.
No, I more or less remember the clause. What
Clause 15 and 16 envisaged that the partners would be liable for profits and losses.
Yes.
There is no specific clause for contribution. Section 33 of the LLP Act was relied upon, but Section 33 of LLP Act envisages a partner to be liable. Now, presumably, I'm not yet a partner because I had elected, I had put in my claim for induction. And that is exactly where it was stalled, stating that, oh, you cannot be inducted unless you pay this amount. So this is a proverbial, the cart before the horse. Because unless I become a partner, I perhaps would not be liable under Section 33, because both Section 33 of the LLP Act and Clause 15 and 16 of the LLP Agreement envisages liability of a partner. So unless you induct me, the question perhaps of me being liable does not and cannot arise. Ladies, you will kindly take up the LLP Act and the LLP Agreement.
This is Section 34 of the LLP Act.
33.
33.
33. 33 was relied upon by the appellants.
Yes.
Obligation to contribute, if I may read.
Yes. Actually, what was relied upon was 24.5.
24.5 is the initial, the basis of the claim. And I'll just touch upon that as well.
Yes.
33.1, if your ladyship kindly takes up,
yes,
envisages the obligation of a partner to contribute money. I'm presumably not a partner because my entire claim is to be inducted as a partner in place and stead of my deceased father, to continue his shareholding, because it is not a secession in the ordinary sense of the term. If I become a partner, if I step into the shoes, your ladyship had very correctly indicated, observed that there is a continuity, so as to say. So I today step into the shoes of my predecessor in interest.
No, I said that not because of my my observation. The clause provides for that.
Absolutely, absolutely. That is the purport of 22.5, which is at page 61.
Yes.
Now, 33 envisages obligation of a partner to contribute money.
So you have not become a partner?
Not yet. That is my
you were at
claim.
the threshold.
At the threshold. At the very threshold.
So you're saying that 33 will not apply? The obligation to contribute will not apply?
Absolutely.
Because your induction
I'm
was
yet
stopped.
to be a partner. And the claim had not been made against my father, who is now deceased. And your lordship will kindly take up clause 15 once at page 254 in volume 2.
Yes.
Losses, clause 16. Clause 15 talks about profits.
Yes.
Clause 16 talks about losses.
Yes.
The losses of the concrete developers LLP, including loss of capital, if any, shall be borne and paid by the partners in the following proportion.
So all the
Both of these
1.28
clauses-
crores and all that would not apply to you.
Not yet.
Yes.
Not unless they concede. And what is my claim? My entire claim in my statement of claim has completely been mischaracterized, as if I'm somebody who is seeking an exit and is liquidating his claim under 24(5). Perhaps that is not correct.
Mr. Banerjee, the only flip side, you please clarify that if you're taking advantage of 33(1), that the negative component and all that, or the obligation for the losses will not apply to you, will you also be able to take advantage of the unsold flats by not being a partner?
If I may clarify, I'm not for once suggesting that upon induction, I will not be liable to whatever is the status of assets and losses. I'm not suggesting that. But whether that can be a precondition to my induction, because I'm not yet a partner, is the question. I'm not suggesting even if I become a partner, then I can wish away this liability by saying, oh, when it accrued, I was not. No, I can't do that.
No, that I've understood. But
I can't do that.
The unsold flats, asking them so many times and they are producing in driblets.
Correct.
That part, can you also claim any share of that?
I'm not
of the
claiming for
profits?
myself at all, Your Ladyship. Because the question that has arisen there is regarding preservation of the share of the deceased partner. Because that would be succeeded to me if I succeed in getting myself inducted as a partner. That is the argument. That if tomorrow I succeed, then what do I succeed to? Whatever would have been the share of my predecessor in interest, and that would presumably include the share in the property which is provided under clause 22(1) at page 255. And it creates a beneficial and legal interest, Your Ladyship. Right title interest in the property. And what I get under 22(5) shall be entitled and shall be paid full payment in respect of the right title interest of the deceased partner. So what we are concerned today, with deepest of respect, is regarding preservation of what would have been the share of my predecessor in interest. I'm today not claiming for me. It is not my claim, because my claim in my SOC is confined to induction and drawing up of accounts afresh. Because both of these accounts, post conclusion of the project in January 2019, has been drawn up in my absence, has been drawn up in the absence of my late father as well.
Of the project?
Of the project. Because 2019-20 was the last year, the audited financial statements of which was signed by the deceased partner.
So you did not, you were not sure as to how much you're entitled to as the son of the deceased partner?
Absolutely not. As is always the case in a suit for accounts. I'm led by Mr. Banerjee.
Yes, you continue, please, Mr. Banerjee.
Wait, sorry, my lord, I was.
Yes.
আমি just 24 দেখাচ্ছিলাম, তারপরে এক্সেপশনটা দেখানো, আপনি এক্সেপশনে স্টপ করেছিলেন।
Lord,
এক্সেপশন।
Yes.
Lord, Mr. Banerjee is the one, my lord, who got that order. He is the best person, my lord, to be heard on this also, my lord, on the 24/5.
Actually, I meant you continue, please, as Mr. Banerjee. But since you've stood up, you can continue. Yes.
I was, my lord, quite happy, my lord, sitting in the side, my lord, for my lord, Mr. Kumarjit Banerjee, my lord, to continue.
Yes.
There was a confusion on that.
No, I actually forgot I was confused about your first name. So I said Mr. Banerjee. But now that you've stood up, you can continue. Yes. Yes.
This is, my lord, when you should not stand up so quickly. I think, my lord.
Yes.
Lord, no, my lord, I was, my lord, showing, my lord, that, my lord, what fell from my lord last, my lord, that in the disclosure with regard to, my lord, sale of the flats,
Yes.
came, my lord, in driblets. Lord, may I just show, my lord, that
finish off that portion, and then perhaps again try and address this issue, because what I think my Mr. Kumarji Banerjee wanted to also say, and that is, when we wanted to be inducted, what we were shown at is to say that 1.28, you better meet this liability. Now, that I think argument on our part is that is not a deterrent to becoming a partner. When you become a partner, then rights and liabilities, everything will flow.
So,
When you become a partner.
Mr. Banerjee, are you saying that with regard to the losses or the liabilities, you will get advantage of that by not being foisted with the losses because you are not a partner as yet? But when it comes to the profits, then you can claim that share as the son of a deceased partner.
In the analysis in the accounts, would have seen that 1.28 was taken out. When the 6 crore was directed to be deposited,
Yes.
the 1.28 was it.
The negative balance was taken
Yes,
from it.
yes. So it is not that I've been given benefit without, or rather given any benefit without the liability. In fact, will recall, and that's what I'll show when Mr. Abhijit Mitra has shown a portion of the recording in the arbitration sitting to say that he held, the arbitrator had initially earlier held that he can't determine this dispute prima facie. It is not really talking about this amount which was secured, directed to be secured. It is really in respect of what we came with, saying that if 34 crores has come up from the assets, then you better give us 1/3 of 34 crores. That argument was not really accepted in the sense of not entertained in that stage, and say no, whatever was existing as at that point, and to preserve the estate or preserve the right of the deceased partner, this has been being given. Because has seen what has happened is after it was sold, then everything has been now shown, and that the arbitrator I'll also show that reasoning bit. Arbitrator also held that everything was shown to have been adjusted as loan repayment to themselves.
Yes.
So without proper accounts being taken, you cannot make the entire LLP into a zero LLP, because nothing will then remain. Everything is being taken away.
So your prayer was not for any share of the profits. You wanted preservation.
Induction
Yes.
and absolute induction and proper accounts. That's my main prayer. I want to go into this partnership firm.
Yes.
That is what is being considered. And in place of the deceased partner, that's why I said any other arguments with regard to my mother was claiming or anyone else is claiming is really not an issue at this present moment. And that's what the arbitrator also holds that. Saying that will come, but doesn't mean that you take away whatever existed of the deceased partner.
Yes.
Kindly come to we had also filed an exception to their supplementary affidavit, which is at page 726, volume 5, was considering. (726) capital B. So when we also filed, this is the last of the pleadings so far as the section 17 matter was considered.
Yes.
It says exception to the supplementary affidavit. That's we'll find that at 726B. And then kindly come to 730.
And what was the supplementary affidavit for?
Supplementary affidavit, again, they had this was, we recall, the supplementary affidavit was at page 631, where they admit a further number of flats which were sold.
Yes. 726B, and which is the other page you?
730.
Yes.
Paragraph 5 will explain what we were dealing with in their supplementary affidavit. claimant takes serious exception to the chart disclosed at page 7 of the said supplementary affidavit. This is one of their affidavit, supplementary, purportedly disclosing the number of flats registered after the demise of late Pawan Kumar Churiwal. Unfortunately, even this chart does not disclose the actual status. Claimants, through a lot of effort, has been able to get hold of the actual status of the flats that were registered after the demise of late Pawan Churiwal from the official portal of the Government of West Bengal, copy whereof is annexed marked with letter A. Bare perusal of the said document will show that there, apart from the flats disclosed by the respondent 1, there are other flats also which have been sold. Claimant has further ascertained that the flats in respect of which third-party rights in lieu of consideration has already been created, but sales transactions are yet to complete in all respects. Chart showing the status of the said unregistered flats in annexed statement marked with letter B. The claimant takes serious exceptions to the statement made in clause 17 to subparagraph L of paragraph 12 at page 12 of the said supplementary affidavit. Respondent 1 has once again made a false statement regarding the number of flats sold during the lifetime of late Pawan Kumar Churiwal. Claimant states, as per the records available in portal of West Bengal, only 7 and not 9 flats were sold during the lifetime of said Pawan Kumar Churiwal.
Very well. So the exception was with regard to the correctness of what
yes.
disclosing.
Well, I am only showing this to show that how much they also suppressed or wanted to conceal with regard to the actual sale which was going on. And hence, the justification of the order is also important. Because if it took 4 directions or 3 directions from the arbitrator and 4 affidavits to take out the actual state of affairs,
yes,
then by the time the arbitration over, nothing will remain of the deceased partner's share.
So therefore 6 crores.
The 6 crores from that 24 deducting 1.2 and then 33, because we are 33%. And he's the highest, single largest shareholding so far as the LLP is concerned. 33%.
Yes.
33.34, I think, that's this. 33.4%. Yes. Now, these charts are also there, just for the records. I don't think need really to go into so much of detail, at page 733 and 740 are the 2 charts, annexure A and B.
And your father is? Sale details.
Yes, sale details.
I thought
No, I'm sorry, Malad.
Yes.
Sale details after demise of Pawan Churiwal, that's page 733. And this is what was also confirmed when they filed their pleading, that is the statement of defense. Subsequent to this, that is not on record.
Yes.
That's at page 181 and 182 of the SOD. I don't think they're disputing it now.
Yes.
If wants, we can put this on record. This is a statement of defense.
No, that's all right. Yes.
That is the position which is now subsisting. Now, kindly take some minutes which were relied upon by Mr. Mitra.
For what? Or saying what?
To show, if I just show that minutes, it will come immediately, that he could not have. Page 774. (775) really, this is what he was relied upon.
That it was the tribunal was not inclined to pass an interim order.
No, at 775, at 776, will find this is what was shown, the difficulty faced by the tribunal.
Yes.
At the bottom of the page, and I'll show the context in which the statement was made, and that is why we got a different relief. The difficulties faced by the tribunal is that although it can prima facie be held that there has accreditation of revenue to the firm, but in order to adjust the expenses, there cannot be any prima facie finding. Therefore, unless the parties agree that on what should be the adjustment, it is not possible for the tribunal to direct the respondent to set about a fixed amount. The other issue is that, according to Mr. Ghosh, appearing for the respondent, claim has to show on his own entitled to can view. Now, this portion is with regard to the 4 crores which is accrued. If my lord, kindly see, my lord, page 775. What is that? Because he just showed, my lord, this portion, and my lord sought to contend as if, my lord, in the main matter, my lord, it could have.
Yes.
Kindly see, my lord, 775. There is a substantial difference between the stance taken by the parties as to whether a settlement can arrive at for purpose of securing the claims of parties to the arbitration. Such difference arise for the following reasons. Claimant states that admittedly from the records before the tribunal appear that after the demise of the deceased partner who is now being sought to be represented by the claimant, there has been accretions of revenue to the firm to the extent of rupees 34 crores. And odd, which would be revealed from the statements furnished by the respondents. Such accretion of revenues on account of sale of 6 flats in a project, Raghu Estate after the demise of predecessor of the claimant, learned advocate for the claimant suggests that prima facie predecessor of the client is alive, then equity demands that 1/3 of the said amount, approximately rupees 11 crores, be set aside till the outcome of the arbitration. Mr. Ghosh, the respondent, does not dispute the fact that there has been accretion revenue to the firm, but he said the same is liable to various adjustments, and such adjustments had to be undertaken by the firm, irrespective of the fact whether such amount is set apart or not. Mr. Ghosh says that adjusting such adjustments, arbitral tribunal will also have to take into consideration that there is another flat belonging to the firm which is in possession of claimant, and separate suit will be. So, the context in which this observation was made, in the 10th sitting is with regard to the 34 crores, because that's not been given to me. I had asked for 11 crores.
Yes.
And will also take another sitting at page 769. Starts at 768. This is the 6th sitting.
Asking for setting
Yes,
aside, setting up
yes,
the
yes,
sale proceeds.
yes. So, and we asked for molding of reliefs, because that is also one of the grounds taken. Page 769, will find Mr. Sansach, the claimant resumes arguments, submits addition to what had been argued on the last occasion regarding non-compliance, non-disclosure of true and proper accounts regarding sale of assets of the firm in the project Raghu Estate. Further order should be passed protecting his client interest if he ultimately succeeds in the arbitration. He seeks such further order by way of direction the firm to set about at least the sale proceeds admittedly received by the firm as disclosed annexure F at page 1 of the affidavit of opposition. Submits that project Raghu Estate had 19 flats, all of which have been
So,
sold.
Mr. Banerjee, what is the point that you wanted preservation and some amounts to be kept aside so that when you, if and when you come in as a partner, you will have something.
Correct.
And initially the arbitrator thought that this cannot be done because of what?
No. The arbitrator thought this can't be done so far as the 34 crores is concerned.
34 crores. And then comes down to 11.
34 would have been meant 11.
Yes.
So he falls back on accepted balance sheet figure. This is what I want to show.
As at 12th of January.
As on 12th of January 2021, what they have given. It's it can't be a dispute so far as they're concerned. Because that's the figure they projected. I'm saying you want much more. And you have taken it away.
And that is the table which you referred to.
That's in the balance sheet. Will recall.
Yes.
I'll just show the
Page 61.
page 61. Absolutely.
785 table is that.
Absolutely. Actually,
785 table is that.
Volume 1 tag. 61. Yes, absolutely, Malad. I'm grateful, Malad. This is Malad, their provisional account, which we are challenging, but Malad, going by this also, Malad has Malad, see, Malad, page 61.
And 733 as well, volume 5.
Yes, yes. That's the balance sheet. 573. 573. My lord, I think my lord 573, if I'm not mistaken, that is
Yes,
my lord,
yes, that's all right. So
Yes.
573 is what
Yes, yes.
the arbitrator relied on.
yes,
573.
correct. And it's the same, my lord, what
That,
as my lord has
note-
seen at
note
page
18.
correct, page 6. Yes, yes, note 18.
Yes.
Correct, absolutely, absolutely. And that's page 61 as well, my lord, absolutely correct. And my lord looks at the award again, my lord, I found my lord,
Mr.
the,
Banerjee, please come back and then conclude on the next day, please. Unless you want to rely on some decisions.
so my lord, my lord, we just wanted, my lord, I'll take 1 minute. My lord, I'm also relying on the principle, my lord, that this is an interim order. My lord, in a section 17 matter where, my lord, it's the arbitrator who's passed it. So, my lord, whether, my lord, the principles of, my lord, wander antax where, my lord, it's a discretionary order, my lord, whether the court will interfere or not, and particularly, my lord, in arbitration matter, that is one of the principles I want to rely on. And secondly, my lord, also Rahul Shah, my lord, which really says, my lord, if it's a claim, then it really, my lord, has to be, my lord, a security, my lord,
That's on
irrespective.
38.5,
That's on. So,
that you don't really
Under-
have to show anything.
that's right. Though, my lord, it's in a suit context, but, my lord, inherent powers, my lord, were used, and here section 17, my lord, is very wide.
Justice Bobde?
Yes. Section
yes.
17 power, my lord, is very wide here.
Yes, very.
One thing, my lord, I thought, my lord, which I don't know, my lord, whether this is the right time. One, my lord, because section 34, my lord, setting aside is on very limited grounds.
Yes.
Whether, my lord, in a section 37 appeal, under, my lord, an order which is in passed in section 17, whether, my lord, similar principles will apply or not, that, my lord, is also issue, my lord, which we couldn't find, my lord, much, my lord, because then will mean, my lord, no reappreciation really of evidence and all those, my lord, principles, my lord, will be coming in, my lord. And then patent illegality, my lord, also attached to the order for, my lord, the court to set aside all those, my lord, issues. But perhaps, my lord, this matter, my lord, may not require, my lord, so much of, my lord.
Very well. So you're saying that same, more or less same principles as an intra-court
Yes,
appeal.
yes, yes.
But at the same time, what are you saying? The details should be gone into or not
No,
gone into?
not gone into.
Not gone into.
Because it is restricted because though it's in the sense from the arbitrator to court, but my lord, the scope of really looking into, my lord, facts and all that, my lord, should be limited. This would be, my lord, my submission.
Very well. So, Mr. Banerjee, do you want to say something else on the next day, or are you done?
My lord, I'll just, my lord, I'll take not more than, my lord, 15 minutes.
Yes, learned counsel appearing for the respondent will conclude his submissions on 27 July 2023.
That's Thursday.
27th is all right?
Grateful.
Yes. Call on the next matter, please.
Take us.
38, Tata Capital Financial Services. 38.
Appear for the respondent.
My lord, this matter, my lord, we had asked for, my lord, injunction as an interim measure, my lord, with regard to certain properties which belong to my learned friend.
Yes.
In view of the fact, my lord, that the properties that they had given as security, my lord, were not adequate. Now, my lord, in view of that, lordship had appointed, my lord, a valuer, my lord, to give a report. The
Yes.
valuer has made a valuation, filed a report, and the report was circulated to the parties also.
Yes.
Now, from the Ricky, may I file my affidavit in reply, my lord? My
We have
lord,
not been served with the reply, my lord.
Not served. Why?
Oh,
So court today, my lord, I have been served.
oh, acha, acha. Tale to, I don't think it should.
Mr. Banerjee, when do you want to come back?
Any day, lordship pleases. Now
But
the
I want to
valuation
take an
report.
exception to the report, my lord.
Why? Without even looking at it, you're saying you
I
want to take
have got it.
exception.
No, exception, my lord. The report was lord, handed over on the last occasion. The affidavit in reply was handed over today in the court.
How much time do you want?
A week's time, my lord. Next week, my lord, I'll come back with the report as well as, my lord,
Learned
lordship
counsel opinion for the respondent intends to take exception to the valuer's report. Stop. The affidavit in reply of the petitioner is filed in court today. Stop. List this matter on 31st July 2023. Stop. A copy of the exception should be served on the petitioner in the meantime. Next.
Grateful, Lordship.
Supplementary affidavit কিসের আবার?
39 Tata Steel Long Products Limited.
My lord, I appear for the respondent, my lord.
My petition, my lord, for
There's a Tata Steel Long Products Limited.
My lord.
yes,
My lord, here, my lord, I am in default, my lord. I still haven't been able to file my affidavit in opposition, my lord.
There was a direction for
There was a
that.
yes, my
direction,
lord.
my lord.
Kindly see, my lord, the last order of 26 June 2023, my lord.
Yes.
My lord, it's ready, my lord. Only affirmation is left, my lord. Will kindly grant me 2 days, 3 days, my lord. I'll file it by the end of this week, my lord.
Challenge to an unilateral appointment.
Yes, learned counsel appearing for the respondent seeks extension of time to file the affidavit in opposition. Stop. The affidavit in opposition should be filed by 26 July 2023. Reply within
2 weeks. my lord.
2 weeks thereafter. Stop. List this matter on 11th August 2023.
Deeply
Grateful.
Non-commercial matter. Number 1, Shrestha rooftop solar SPV.
So ma'am, for the petitioner, I have instructions to withdraw this matter.
Any orders passed in this?
Yes, your lordship, orders were passed.
I can't hear you.
Directions for affidavits were given.
Miss Oja,
Yes, ma'am.
you're for the alleged contemner?
Lordship, the response. Alleged containers number 3 to 6.
Yes, she wants to withdraw. Both the parties are represented. Stop. No, the petitioner as well as the alleged contemnor numbers 3-6 are represented. Stop. The advocate on record of the petitioner, you're the counsel.
Advocate on.
The advocate on record of the petitioner seeks to withdraw the contempt petition. Stop. CC 7 of 2023 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Deeply obliged. 3 to 6. 3 to 6.
Item number 2, Mampi Beldar.
My lord, I appear for the alleged contemners. My lord, the report was prepared. My lord, the police verification says goes against her, and she was asked to show cause, but she did not turn up. My lord, my junior is there. She can hand over the office report.
Who is she?
My lord, Miss Shaw is there.
My lord, I am.
No. Who is she? You're saying she did not turn up? Who is she?
My lord, the petitioner.
Say that, please. Don't say
I'm
she.
sorry. I'm sorry, my lord. The petitioner did not turn up. There is a report, my lord, an office report. She has not been able to give her birth certificate, my lord. And your lordship is aware that the police verification is incumbent before issuance of her passport, and the police verification is against her.
Have you handed up a copy of the report to your learned friend?
No, ma'am.
Yes, give a copy, please.
Lord, may I submit, Lordship?
Have you seen the report?
Lordship, may I kindly.
I can't understand what you're saying.
Lordship, may kindly give me some time, Lord, so that I can come back, Lord.
Yes, learned counsel appearing for the alleged contemnor hands up a report of the Regional Passport Office dated 20th July 2023. Stop. Counsel submits that the petitioner did not appear before the authority and that the police verification is also against the petitioner. Stop. Next.
May I file, if required, my Lord, a reply to this report, Lordship, on affidavit, Lordship?
Yes, list this matter on 4th August 2023 for the reply of the petitioner to be filed in the interregnum. Stop. A copy of the reply shall be served on the alleged contemnors well before that date. A copy of the report is kept on record.
Item number 3, Mickey Metals.
And I appear for the petitioner, my lord. Service was attempted, but my lord, may I file the copy, my lord? My lord, it has returned as a service has been returned, my lord, due to my lord, inavailability of the respondents. Lordship will kindly take Lord, page 5, my lord.
Yes, page 5, you have stitched it in a manner that I can't see the dates. I can't see the dates. File it once again, please. Look at the dates. None of the dates are visible. Yes, the affidavit of service.
Lord, may I only pray for one more thing? My lord, the arbitration agreement, my lord, is not stamped. Lordship will kindly, Lord,
No,
impound
no,
it,
first you have to
Very
file the affidavit of service properly. The affidavit of service is not properly stitched. Stop. None of the dates are visible from the relevant page of the affidavit of service. Stop. List this matter tomorrow.
Grateful.
At least you should apply your mind when you're stitching. None of the dates are visible on the left-hand column.
Sorry. Item number 4.
Yeah, I appear for
Anyone
the
has a
respondent in this matter.
My lord, I am appearing for the petitioner in this matter.
Yes.
The petitioner in this matter is a partnership firm providing carrying and forwarding services to clients. And the respondent in this matter is a healthcare company which produces medicines and medical products.
Now, are you, Mr. Shahu, are you objecting to the
Yes, my lord.
section?
What has happened, my lord? There was an agreement of 2014. It is their own case, and it is true also, my lord, we agree that it was extended till 31st of March 2016. Thereafter, they say, the petitioner says that yet thereafter the parties carried on business. So, my lord, the disputes that had arisen now, they say, cannot be, my lord, under that agreement.
My lord, the security.
Very well. Yes, you.
My lord, the security deposit that was of rupees 25 lakhs that was paid was pertaining to the agreement entered into in 2014, which ended in the year 2016. However, through the conduct of the parties, we have continued business till 2021. And when through their mail, they had unilaterally closed the operations, and in such mail, they had stated that within a year, they shall pay back the security deposit pending commission and pending interest on such security deposit. However, till such date, we have not received any of the following.
Very well. Show me what is the first agreement about?
My lord, the agreement is in page 14. The respondent is a manufacturer of medicines and medical products.
Yes.
They were supposed to transfer their goods to Odisha, where the carrying and forwarding agent was supposed to store them and transport such medical products to medical practitioners or stockists. And that was the only job.
Who is the they?
The petitioners, my
So
lord.
don't say they, say the petitioner. How will I understand?
The petitioners were supposed to store them and transport them to the stockist, as would have been advised by the respondent in this matter.
Yes.
My lord, the respondents in the year 2016, 18, and
what is the, show me first, don't jump. You showed me page 14. What is page 14?
my lord, the agreement with the agreement between the parties, the petitioner and the respondent.
Give me the date. One more question. I'm going to dismiss the application. Place the facts properly.
My lord, the agreement executed between the parties dated 19th March 2014.
Yes.
The term of the agreement is stated in page 16, which is, it starts from 1st April 2014, and the agreement shall be in force till 2016.
Where, which term? Yes. Till 31st March 2016.
Yes, my lord.
Very well. And then what happened? Where is the arbitration clause?
My lord, the arbitration clause is in page 30 of that agreement.
Yes. And then?
My lord, even after the expiry of that agreement, we have sent them invoices and regular updates, to which they have replied to an email that they cannot pay the expenditure which were incurred by us in transporting and storing for 2016-17. And that mail is annexed here. Page 52, that they shall not be able to pay the expenditure incurred by us. However, they have agreed to pay the expenditure incurred by us for the year 2020-21. This clearly shows that they were in knowledge that the business between the parties, the petitioner and the respondents, were continuing till 2021, when they unilaterally.
Wait, you're referring to a page. Come to that page.
My lord, page 52.
Yes. What does it say?
My lord, that
if you're not ready, take time.
my lord, my lord, the page says that the respondent shall refund commission up to December 2020, interest on security deposit, and thereafter the total dues here, which amounts to 3,69,354.
Where does it say all this?
My lord, in page 52, annexure E.
Learned counsel appearing for the petitioner needs to get ready in the matter. List this matter tomorrow. Next.
Item number 5,
Lord, I appear on
KP
behalf-
Media and Entertainment.
My lord, I appear on behalf of the petitioner. My lord, praying for 2 weeks' time in order to effect service, my lord, because upon respondent number 1, when the service was made, it is showing that the respondent number 1 has been shifted to any other place.
When was the service made?
The service was made on July 12, 2023. The section 21 notice was delivered. Therefore, we have made the service of.
Yes, list this matter after 1 week as prayed for. Stops fresh service to be in the meantime. Next.
Item number 6, K2V2 Hospitality.
My lord, I appear on behalf of the petitioners. My lord, on the last date, my lord, the
You
service
don't know how
was
to use
not-
the microphone.
My lord, as because on the last occasion, the service was not completed, my lord had kept it today. My lord, we have completed service upon.
Your lordship, I am appearing on behalf of the respondent number 2 and respondent number 4, your lordship.
This is what, 11?
Yes, my lord. It's a section 9, section
What about
11.
the other respondents?
My lord, all the respondents have received it. Only one respondent, respondent number 4, who is staying in the area Baghiyati Road. His service is still not completed for the second, but the first, the main petition has already been received by them as per the track report, my lord.
What is the second?
My lord, the notice that the matter has been kept today, I had said two
So
separate
the
notices.
petition has been served on all the respondents?
Yes, my lord.
Very well. Yes, are you objecting to the section 11?
Lordship, I want to file an affidavit, your lordship.
Why?
Because there are certain documents which my learned friend has not annexed in the copy of this
No,
section.
no.
11.
Affidavit in opposition, not for the asking. What documents? Tell the
The
court.
documents is that.
Microphone, I can't hear you.
The documents is that my learned friend allegation is that the fire NOC has not been obtained within the time as specified by the contract between that, which is signed between the parties. That
my lord,
NOC has
all
been
these can
obtained
be
and
referred
has
to
been.
Know the system of the court? Shall I dismiss the matter? Yes.
That NOC has been obtained and has been given to my learned friend's client on 15th of January 2023. Thereafter, time and again, bill has been issued to my learned friend's client to make payment because they have been given possession. Now they have not made that payment, and in the meantime, on February 2023, they have issued a notice for termination and a file a section 9 application, your lordship. I have
So you are the contractor?
Lordship, I am the landlord, your lordship.
Landlord?
Lordship.
And who are you?
My lord, I am a lessee in the said. I was a lessee. I was supposed to be given the said term of lease from the from September 2022. But as they continue to delay the same, we first terminated the said lease leave and license agreement, both of them, around November 2022. Thereafter, after we had terminated the same, they had sent us the NOC only in January. But before that, we had already initiated termination of the said agreement. We had made over certain.
Very well.
advance
Learned
payments to
counsel
them.
appearing for the respondents seeks to file a short affidavit to bring on record relevant documents. Stop. The affidavit should be filed by 28th July 2023. List this matter on 2nd August 2023. Reply if any in the meantime. Next.
Item number 7, Ritesh Agarwal.
Your lordship, in this matter, Mr. Siddhartha Banerjee is appearing for the petitioner. Your lordship, he is engaged on another court. I'm praying for not today.
I'm appearing for the respondent. My lord, your lordships had kept today for addressing the issue of maintainability of this application.
Yes, please start. Yes.
But AP 371 is the section 36 application, and even the section 34 application is also there in the list as item number 10. Now, item number 11. Lord, 3 documents have.
This is the maintainability of the stay.
lot of the section 34 application
34.
should have been taken first, but it's item 11. I can wait, my lord, if lordship wants, my lord, till item 11.
No, you wanted to take the amendability point.
yes, my lord.
Please take it.
Yes.
Yes.
But will kindly consider, my lord, in the section 36 application, my lord, 3 documents I will show from where it will be indicated that the respondent was served with the copy of the award. My lord, he deliberately chose not to file a section 34 application within the stipulated timeline under section 34 subclause 3. And his basis of filing this application is the date of knowledge, where he claims that he has come to know from the execution petition which was served upon. Now, from the petition itself, I will show your lordships that the address of the petitioner in the section 34 application is same as where in the execution petition also the address is the same. But in both the execution petition in the section 34 application, same address, my lord, which is at Howrah. And even in the award, I'll indicate your lordships the page numbers, my lord. Even in the award, the petitioner was a party, and the address was mentioned as Howrah, and the copy of the application and the copy of the award was also served at Howrah. Lord, will kindly take up. Lord,
So you're saying that the 36(2) is not maintainable.
34 itself is not maintainable because of the ground that it is barred by limitation. Hence, no application or interim reliefs can be granted under section 36. My lord, that is the argument.
Because 36(2) presumes a valid 34.
34, man.
Yes.
Only if he can satisfy that he has filed this petition within time, he'll be entitled to, my lord, seek for further interim
And
orders.
what is the delay according to you? How many days?
Not the delay according, my lord, we do not have the track report. I'm going to argue on the point of deemed service under section 27 of the General Clauses Act, read with section 3 of the Arbitration Act, and also section 114 of the Evidence Act. Lord, according to me, my lord, the service has been more than a year. It has been served upon the respondents, the petitioner in the year 2020, April 2022. And as per their date of knowledge, it is April 2023. So there has been a delay of almost 1 year in filing this petition.
Yes. So you're saying you don't have the track report, but you're saying that deemed service.
Yes, my lord, as per section 27, because it is correctly addressed to the address of the petitioner.
Yes.
So it will be presumed that the award has been served upon the petitioner, and I'll be relying on some decisions of the, one decision, division bench judgment of our High Court and one division bench judgment of the Bombay High Court.
Yes. That's on section 21.
But section 27 of the
27.
General Clauses Act, read with section 3 of
Very
the Arbitration and Conciliation Act.
Yes.
Will kindly considers, my lord, page 1 of the cost title. My lord, it's a petition filed by Ritesh Agarwal.
Yes.
The address says that he is the proprietor of Shri Sham Steel, and he's running its business, and it's residing at, your lordships will kindly note the, my lord, the address, Harogang Bazaar, 80 by 81, Shri Aurobindo Road, 3rd floor, flat number 304.
Yes.
Lord, will kindly also takes up the award at page 17 of this application.
Yes.
Lord, he was respondent number 3, Ritesh Agarwal, same address at what is described in the petition. And I'm not addressing on the merit throughout the case. My lord, throughout the petition, my learned friend's case is that he was.
This is Shyam Bihari Sharma.
Is the arbitrator, my sole arbitrator.
Unilateral appointment?
Unilateral appointment.
Yes.
And at page 23,
Yes.
Lord, it's an award dated 30th day of December 2021. There are 3 postal receipts which are enclosed.
30th?
Like 30th of December 2021.
Yes.
And 3 postal receipts are disclosed, my. First to the proprietorship firm, then, my lord, the second one, your lordships will kindly mark, Ritesh Agarwal, and the date is 17th of January 2022.
Yes.
Lord, the third relevant page is the execution petition, which is at page 41 of my learned friend's application, which it starts from page 41 and the relevant page is page 42.
What is this?
my lord, the execution petition, because his case is that he's come to know about the award from the receipt of the execution petition. But page 41
Yes.
and page 43, your lordships will find, my lord, Ritesh Agarwal, same address, Harogang Bazaar, 80 by 81, Aurobindo Road, 3rd floor, flat number 304. So on 3 occasions, my lord, same address, my lord, in his petition under section 36, in the arbitration tribunal where all the correspondence were acknowledged and delivered, same address, and even in the execution petition also the same address of the petitioner.
Yes.
My lord, will now kindly takes up the Arbitration and Conciliation Act, my lord. And I'm not, my lord, I do not have other documents to disclose. Even from the loan application form, it will be evident that it is the same address which is there in the petition and all the other 2 places which I just indicated to your lordships.
Yes, Arbitration Act.
My lord, section 3. But the deeming provision, I'll rely on section 3 sub 1.
Yes.
Receipt of written communication, unless otherwise agreed by the parties, any written communication is deemed to have been received. Your lordships will kindly note the word deemed. If it is delivered to the addressee personally or at his place of business, habitual residence or mailing address. And thereafter, my lord, clause B, my lord, I will not be relying upon, but it's still, my lord, relevant for the purpose of, my lord, may be relevant for the purpose of this matter, my lord, if none of the places referred to in clause A can be found after making a reasonable inquiry, a written communication is deemed to have been received if it is sent to the addressee's last known place of business, habitual residence or mailing address by registered letter or by any other means which provides a record of attempt to deliver it.
Yes.
Now your lordships will kindly take up the General Clauses Act. So by virtue of this particular section, my lord, it creates a deeming fiction by which if the arbitrator has correctly, my lord, addressed the letter to the petitioner by putting his address, which was as per the record available with him, my lord, it will be deemed to have been served by virtue of
Section 27.
Section 27.
Yes.
Now, meaning of service by post. Now, the reason I'm relying upon this because the delivery of the award was by virtue of a registered post, where any central act or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression serve or either of the expression give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying, and posting. Well, the 3 words are very important: addressing, prepaying, and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time which the letter would be delivered in the ordinary course of post.
Yes.
Execution affidavit service. But I will now hand over one document, my lord, the affidavit of service,
Yes.
my lord, which was filed in the execution petition, which would also indicate, my lord, the postal receipt, because the execution application has the postal receipt. Copy down.
Have you shared it with Mr. Dwivedi?
No, I'll just share it, my lord. I will just share. I will just share it with him, my lord. I'll just rely on it and share it with you. I do not have an extra.
That's
copy.
all right. Yes.
Now, this is the affidavit of service which was filed before the executing court, my lord.
Yes.
My lord, the respondent number 3, your lordships will find Ritesh Agarwal, same address, Harogang Bazaar, 80 by 81, Sri Aurobindo Road. And at page 9 is the postal receipt. It shows item returned, addressee left without instructions. This is why, my lord, in the section 36 application, they have enclosed the executing court's order, whereby they have tried to show that even we have not been able to serve them the execution petition at the first attempt. Lord, my argument would be, even assuming that the addressee left without instructions, if I have correctly, my lord, addressed the letter to him, it will be deemed to be a valid service, relying upon section 27 of the General Clauses Act and at section 3. My lord, exactly similar situation arose before the Bombay High Court. I'll place the division bench order before your lordships.
So you're saying that this endorsement as of 19th October 2022, that will not be held against you
Not be held
because of
against.
section 27.
Section 27 as well as section 3. And in such a situation, my lord, section 114 of the Evidence Act will also come into effect. But we'll kindly also, my lord, consider section 114 of the Evidence Act.
Yes.
Court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. And subclause F,
Yes.
the common course of business has been followed in the particular case. My lord, your lordships will also see illustration F. The question is whether a letter was received. It is shown to have been posted, but the usual course of post was interrupted by disturbances. Lord, under this section, my lord, the court will presume that if the ordinary course of business have been adopted to by addressing the letter to the petitioner, but the court will presume that that thing might have happened, but to be correct and true. But an exact similar situation fell before the Bombay High Court in 2018. I'm handing over a copy to my learned friend, my lord. 2018 SCC Online Bombay 916. It's a division bench judgment of the Bombay High Court. I'll briefly indicate the facts which had fallen before this honorable court, my lord, before the Bombay High Court. This appeal, my lord, paragraph 1, this appeal under section 37 of the Arbitration and Conciliation Act arises from an order dated 2nd of August 2016, whereby the appellant's arbitration petition has been dismissed as barred by limitation. My lord, paragraph 2, my lord, it starts from, my lord, the last 8th line, paragraph 2.
Yes.
So your lordships are fine. It starts with award was forwarded to the parties. The award was forwarded to the parties by the learned arbitrator by registered speed post under his covering letter dated 10 December 2012, which was addressed to two address of the appellant, namely at plot number, I'm not reading out the address, and B2 sector 31 Noida. For short the Noida address. However, the postal authorities returned the envelopes containing the award with the remark, my lord, this is in Hindi, but this, my lord, means that they have left the address.
Yes.
And the second one, no such firm at this address dated 17 December 2012 and 18 December 2012 respectively. My lord, yes. Paragraph 3, my lord, similar contentions was raised before the Honorable Bombay High Court. On the other hand, it is the case of the appellant that the appellant had not received any notice of arbitration proceedings and thus the appellant could not participate. It is the case of the appellant that the appellant had become aware of the arbitral award for the first time when a copy of the execution petition in execution case number 108 of 2015 as instituted by the respondent before the Court of District Judge was received by the appellant on 29th of October 2015. Immediately on receiving the knowledge of the award, the appellant had approached this court on 11th December by filing arbitration petition in question challenging the award. My lord, the same cause of action also in paragraph 23 of my learned friend's petition.
Yes.
Lord, paragraph 4, Lord, straight away, my Lord, paragraph 10 is the question which was framed by the Honorable Bombay High Court. Though many contentions are raised, the short issue which is required to be decided in this appeal, paragraph 10,
Yes.
is as to whether the award in question can be considered to be delivered on the appellant as per the requirement of section 31 subclause 5 of the Act. Paragraph 12, thereafter, the delivery of the award on a party to the arbitration proceedings involves creation of bundle of legal rights, my Lord. Thereafter, it states, my Lord, what right accrues to a petitioner in receipt of the award, which is either filing for rectification, correction under section 33 or file a section 34. My Lord, paragraph 13, thereafter, in the facts of the present case, it is not in dispute that the appellant did not participate in the proceedings before the arbitral tribunal, same as in the present case, as according to the appellant, it had no notice of the arbitral proceeding. It is also not in dispute that the arbitral tribunal made an award on 7th of December 2012. The case of the respondent is that the learned arbitrator forwarded a copy of the award dated 7th of December.
Mr. Sharkar, I will read the facts part. You tell me what the court held.
Yes,
please. Which paragraph is that?
But will kindly comes to page, paragraph 23, page 7. Lord, paragraph 22, your lordships will first consider, my lord, I'm sorry.
Yes.
Lord, in the circumstances, considering the provisions of subclause 1 of section 3, read with provision section 31, subclause 5, we are of the clear opinion that when the learned arbitrator had forwarded the award at the last known address of the appellant, namely B2 sector, and the same being returned by the postal authority, with the said remark as noted above, it is required to be held that an appropriate and lawful delivery of the award on the appellant on the day the same was attempted to be delivered, namely 17th of December 2012 and 18th of December 2012. As
Very well. So deemed service.
my lord, and last I'll just take your lordships to, my lord, the concluding remarks at page, my lord, at paragraph 38. At paragraph 34, my lord, one paragraph I would just like to indicate, because here the Bombay High Court goes ahead to discuss a Supreme Court judgment in the case of Madan and Company versus Wazir's son.
Yes.
But 1989, 1 SCC 264. But here was a situation where the addressee had left, not same as in the petitioner's case, which I just indicated from the affidavit of services.
Yes.
And your lordships will kindly consider the judgment which has been cited. Lord, he can, well, I'm just reading the portion which is set out at paragraph 34. He can so manipulate
Yes.
matters that it gets returned to the sender with vague endorsements such as not found, not in station, addressee has left, and so on. It is suggested that knowing that the tenant is away from the station for some reason could go through motions of posting a letter to him, which he knows will not be served. Such a possibility cannot be excluded. But as against this, if a registered letter addressed to a person at his residential address does not get served in the normal course and it is returned, it can only be attributed to the addressee's own conduct. If he is staying in the premises, there is no reason why it should not be served on him. If he is compelled to be away for some time, all that he has to do is to leave instruction with the postal authorities, either to detain the letters addressed to him for some time until he returns, or to forward them to the address where he has gone. Or
Very well. Mr. Sharkar, so what does the court hold? This is Wazir, Madan and Company.
My lord, paragraph 38. My lord, the court held that, my lord, it is to be construed as deemed service, my lord, considering section 27 of the General Clauses Act and section 3 of the Arbitration and Conciliation Act.
Paragraph 38 does not refer to any other provision, just says that
but previously the judgment discusses, and then 38 and 39 also, my lord. Was not, my lord, the last page was not a correct address. However, the summons of the district court under the execution proceedings was forwarded on the same address, and the same was received by the appellant. Furthermore, the Noida address has also been incorporated by the appellant in the title of the petition in question filed under section 34 of the Act. We therefore cannot at all accept the case of the appellant on the change of the address. In this regard, In our opinion, the observation of the Supreme Court in Wazir San, as noted by Asman. Now, the next judgment I'll rely upon is a division bench judgment of my Lord R High Court on a similar situation, my Lord. Ashok Kumar. Copy though. This is a Manupatra, my Lord, printout. My Lord, 2018 1 CHN Calcutta 391. I'll only rely upon the relevant portion at paragraph
2018 1 CHN Calcutta 391.
391. Magma FinCorp Limited versus Ashok Kumar.
Yes.
Not paragraph 10. But a similar situation arose, my Lord, regarding non-receipt of the award. Matter went up to the appeal, my Lord. The facts are at page paragraph 1.
Yes.
And at paragraph 10, my Lord, this honorable court holds that it is a rule of interpretation that in construing the scope of legal fiction, it would be proper and even necessary to ascertain as to whether all those facts on the fiction can operate have been performed. The records reveal that the envelope containing the forwarding letter and the arbitral award dated were properly addressed to the respondents at the addresses mentioned in the arbitration agreement, and proper stamps were affixed, and the envelopes were posted from Prinsep Street Post Office on August 21, 2014. Due postage was paid by affixing prepaid adhesive postage stamps, and postal article was duly put in course of transmission by registered post in the manner provided in Chapter 6 of the Indian Post Office Act 1898. The postal acknowledgement cards have not been returned by the postal authorities to the learned arbitrator. The procedure for serving notices as mentioned in the arbitration agreement has thus been strictly followed, and as such the application of legal fiction, the communication should be deemed to have been received on the day it is so delivered.
Yes.
Lord, so from these two decisions and from the, my Lord, the pages which I showed from the section 36 application, same pages are also there in the section 34 application. The petitioner was at all material times aware that this arbitration proceedings have been invoked and an award has been passed against him. And since, my Lord, in the execution.
So therefore you're saying that the delay, it's a 34.3 point.
34.3 point.
That outside the 120 days.
Outside the 120 days, my Lord, the delay cannot be condoned. It's 90 days plus, my Lord, 30 days can be condoned. Now here, my Lord, by deeming fiction, it can be presumed that the award was served way back in, my Lord, 2022, either in the month of March or April. And the petitioner came as late as only in the year 2023, April. And it is the same address.
One problem, Mr. Sharkar, that is of the unilateral appointment.
But that will come into question, my Lord, only if he is today able to demonstrate that he's entitled to file this petition. Thereafter, your lordships will consider the merits.
The award is a nullity, then what happens?
Lord, the award in this case is not a nullity because, my Lord, his petition's case mentions that he was not a
No,
part.
is there a waiver on his part?
Not a waiver, my Lord, implied waiver. That is
Implied waiver.
That's what I'm going
The
to argue.
proviso to 12.5 says express waiver.
Well, I will place on, my Lord, I'll rely on a division bench judgment of the Madras High Court also, my Lord.
Saying what?
Lord, on an implied waiver, whereby way of exchange of correspondence and letters between the parties, if it can be proved that the petitioner was aware and in spite chose not to participate, cannot later come and take a point of unilateral appointment. It's a Justice Sanjeev Banerjee's order or a judgment of the division bench, but I'll rely on that. But that question will come in my respectful submission is only when my learned friend is today able to.
Because unilateral appointment now is something which is totally contrary until and unless there is a party, not the petitioner, of course, the person who would be affected by the unilateral appointment expressly waives the proviso to 12.5, expressly waives 12.5 by operation of the proviso.
But section 12.5 proviso is clear. Well, I've read your lordship's judgment also, my lord, in the Aditya Birla matter. But
Over there was a,
there was
correspondence
written correspondences between the parties. I'll still try to demonstrate, my lord. But that's on merits. I will have to address it if your lordship ultimately allows this application. But to get to that, my lord, my learned friend has to prove that because
Yes, Mr. Dwivedi, what do you want to say?
Lord, in this matter, I have a leader, my lord.
That's the only thing you have to say.
Lord, and apart from that,
Very well, Mr. Dwivedi, you will argue on this on the next day, which is tomorrow. All right? You will argue. Get ready in the matter.
one point I want to argue today, my lord, is that they have not shown that I have taken the plea that the arbitration is non-starter because section 21 notice has not been served upon us.
Section 21 notice.
Yes.
So what were you hearing all this while?
I don't know if they have shown the award, they have shown the track report of the award, they have.
Very well. Tomorrow you show the 21 notice. All right.
21.
You invoke the arbitration clause.
See, I invoked it
Unilateral
because there was a default on the part of the petitioner.
Very well. So default?
A default, it was a loan transaction where the petition.
Very well. So you invoke the 21.
Yes, I
So
invoked
you
it.
will have to show that it was that is the first knowledge which the petitioner has.
Very well.
Unless you've given demands, letters of demand before that, the petitioner is put on notice that now you're going to do something to invoke the arbitration clause. So show that tomorrow.
And apart from that, my lord, arbitration agreement was invoked against a dead man, which they know that.
Mr. Dwivedi, you cannot argue piecemeal.
No.
You have to argue together. First you say I have a leader, then you will say one point, then another point. No.
I'll just, my lord, one thing I want to indicate because I've been hearing my learned friend taking this point from day one.
Yes.
The petitioner as
Day one as in the date when he received the 21 notice.
from the day of filing this application, my lord, where he has always been taking the point that the award was passed against my father who has died. Lord, from the documents, I will show that the petitioner was also a co-applicant. He was a co-borrower to the loan agreement. He was a party to the arbitration agreement. So the fact that he's stating today that it's passed against my father, which is induced by fraud or corruption, will not stand in the way, which I will also disclose from
So you're
documents.
seeking unconditional stay of the award? Yes, not sure.
Yes, my lord.
Yes, unconditional stay for fraud or corruption.
Yes.
Don't have a point there. I better tell you. You answer the preliminary point first.
Yes, I will.
Learned counsel appearing for the respondent bank, respondent FI, financial institution. Are you a bank or what are you?
Non-banking financial institution.
Respondent NBFC takes a point of maintainability on the ground of deemed service of the award, of the impugned award to the petitioner. Stop. Council relies on section 3 of the 1996 Act, section 27 of the General Clauses Act and section 114 of the Indian Evidence Act in support of his contentions. Stop. Next, list this matter tomorrow for council to conclude the point of maintainability and for the petitioner to answer to the same.
Grateful.
Item number 8, Sri Vimal Chandra Roy.
My lord, service is not yet complete, my lord.
Did you take up this point 2-3 times before?
No, my lord. My lord, on the
No.
previous occasion, we were asked to communicate the order. On June, it was serviced first, then we were asked to communicate the last order. That was on 13 July, my lord.
So where are they based? Where is the respondent based?
My lord, Putiari, Purbo Putiari.
So when did you attempt service? You don't have the papers with you or what?
No, my lord.
Why?
My lord, because service was not yet complete, so my.
List this matter tomorrow. Next. Get ready. Argue the matter.
Item number 9,
May I
UK
please, my lord?
Mechanical Engineering.
This is my, my lord, with the affidavit of service. Application, my lord, for extension of the mandate of the arbitrator. my lord.
Microphone, please. You're the respondent.
Yes, my
Are
lord.
you agreeing or not agreeing?
Yes, my lord. We have no objection to it, but my lord, I would like to bring to your kind attention that the total amount of claim as disclosed in the statement of claim and the statement of defense, both are above 10 crore.
10 crores. So what are you saying?
My lord, that it should have been filed in the commercial division.
Is that correct? Mr.
10 crores are okay. Huh? My advocate on record says that the claim
I
is
can't
not
hear you.
above-
Microphone.
My lord, my advocate on record says that the claim is not above 10 crores. And my lord, the hearing, please. The hearing is complete. Only, my lord, the award is required to be passed.
So arguments are done.
Yes, my lord.
So
Everything
this is
done.
under the first one under 29A4.
21, 29, first one, my lord.
First one.
30th
No
April,
earlier applications made.
no earlier application.
So when did the mandate terminate?
30th April 2023. my lord.
The 6 months also.
6 months also.
So you took the 6 months extension under 29A3.
My lord, by consent.
I can't
my
hear
lord.
you.
My lord,
Microphone.
by consent, my lord, it was extended. My lord, the parties made extensive
First, tell me when did the
submissions.
1 year,
My lord, the 1 year, my lord, expired on October 2022.
give me the date, please.
My lord,
What is
30th
this
October
October?
2022, my lord. 30th October 2022.
Yes, 1 year extend, then 6 months taken when?
Thereafter, my lord, the 6 months period started and it expired, my lord, on 30th of April 2023.
And this is the first 29A4
This is the first 29 days.
and arguments are done.
Arguments are all complete, my lord. Only the award has to be passed and, my lord, the parties will submit their written notes of arguments.
Learned counsel appearing for the petitioner and the respondent agree that the 1 year under section 29A within brackets 1 of the 1996 Act expired on 30th October 2022. Stop. The parties thereafter consented for another 6-month extension up to 30th April 2023. Stop. This is the first application under section 29A4 for extension of the arbitrator's mandate. Stop. Learned counsel, next learned counsel appearing for the parties submit that, say that arguments are complete in the matter and only the award is to be made. And only the award is to be made. Stop. Next, since the parties are ad idem on the point of extension of the arbitrator's mandate at a learned arbitrator's mandate, and arguments have already been concluded in the arbitration, AP 459 of 2023 is allowed and disposed of by extending the mandate by 3 months from today.
Grateful, my lord.
How much did you want?
My lord, I had, my lord, paid till 30th September 2020. Since, my lord, it is the award which is only to be, my lord, passed.
Is extended till 30th September 2023. Stop.
I'm grateful, my lord.
Yes. 30th September 2023 as contained in prayer A of the application.
I'm grateful, my lord.
Item number 10, Shubhankar Chakraborty.
My lord, I beg to appear on behalf of the petitioner, my lord.
Well, I'm
Yes.
responding.
My lord,
34.
34, my lord.
Yes.
But it's an unilateral appointment.
Microphone, please. Don't go on saying the same thing, unilateral appointment. I will now hold that the unilateral appointment is fine. Yes, just give me the grounds under section 34.
Well, the grounds were already on the earlier occasion I had submitted. The only point was that to give a guarantee, whether it's a cash or a bank guarantee, and
It's a
thereafter
point of law.
lordship,
Under which subsection of 34?
36(3), my lord,
36(3).
lordship. Our stay application is there, my lord. Further.
So 36(3) presumes a valid section 34. Is your 34 within time?
Lordship.
It is.
Lordship.
Is it within time or not?
Within time.
So it's a 36(3).
36.
So you want what? Unconditional stay?
No, my lord.
Then
My
why are you
lord,
saying 36(3)?
My lord, I am ready to give my deed as a guarantee, my lord, because I don't have a cash up to 16 lakhs.
What is the awarded amount?
16 lakhs, my lord.
16 lakhs.
I'm a small vehicle owner, my lord,
And how do you propose to secure it?
through my deed, my lord.
What deed is it?
It's a sale deed, my lord, though it's in Bengali, but I will translate it also. If
Can't you understand? You have to describe the security and the court will have to decide whether it is adequate, sufficient security for the, can't you understand?
no, it's a sale deed, my lord, where the value is more than 16 lakhs here, my lord. The value is more than 16 lakhs, and
You don't think it's important to tell the court what the sale deed is for? It's what is it about? What it is about?
lordship, I'm fine.
Every time you're not ready in the matter, I'm going to impose costs on you. I'm telling you today. This is the third time. I remember faces.
Lordship, it is a land with a building of 196 square foot, and it's at Howrah, the Bastu land, where the total value is 16,99,500.
16 or 60?
16. Well, the award is of 16 lakhs, 16 lakhs. It is the
So
value. Of,
this fits into that 16
it
lakhs.
is more than that, my lord. It is more than that.
What do you have to say?
My lord, pass an,
Microphone, please.
my lord can pass an order, my lord, subject to my lords.
Pass an order saying not accept.
No, my lords, my lord can accept, subject to.
Valuer ke aase dekho to.
There's a award, my lord, awarded amount is 16,66,511.
Show me the awarded amount, please.
Page 37, man.
Where do I get the awarded amount?
Page 37, my lord.
No, there are many amounts. Which one are you
Well,
referring
it's-
to?
I award B, my lord.
Doesn't say a total amount. Which one?
Let's see, my lords. I award director of a sum of 16 lakhs, my lord, page 37, B.
Paragraph 22, my lord, is the award amount.
So 16 lakhs, 16.66 lakhs along with 3% interest.
My lord.
Well, this calculation is also wrong one, my lord.
The petitioner seeks stay of an award passed by a sole arbitrator on 20th March 2023 of an amount of rupees 16.66 approximately rupees 16.66 lakhs. Stop. The impugned award does not contain a specific statement as to what the exact awarded amount is. Stop. The last few paragraphs note the principal amount of rupees 16,66.511.86. 66 এর বদলে একটা ইয়ে হবে comma 511.86 with varying rates of interest provided at different stages. provided at the different, provided in the different points. Stop. Next, learned counsel agreeing with the petitioner submits that the petitioner does not have any other security to offer for stay of the award, except for a piece of land situated at
my lord,
Howrah, measuring about
measuring about 5 decimals in total,
5 decimals,
and that market value is 19 lakh 269 rupees.
the
Sorry, 19
market,
lakh 20,000.
the market value of which is approximately rupees 19 lakhs. Stop. What is the judgment where the court has said that this can be done? Neetu Shaw. You have to find out whether the appeal court and the Supreme Court, whether this has been disturbed or not. Next, section 36 within brackets 2 and 3 does not specify the form of the security, save and except 2 and 3 of the 1996 Act. Does not specify the form of the security, save and except that the court will have discretion to impose conditions for stay of an award under 36 within brackets 2, stop. 36 within brackets 3 serves, directs the court to the provisions of the Code of Civil Procedure, 1908, more specifically Order 41, as guidance, as guidance. Stop. The fact that security other than money can be given for stay of the award was decided in Neetu Shaw versus Bharat High-Tech Cements Private Limited in AP 82 of 2021. Stop. Subject to the said decision being interfered with, this court is of the view that security in terms of land, in the form of land, can also be offered by an award debtor for stay of the award, provided the value of the security is commensurate to the awarded, to the award, if the award is in the form of a money award. Stop. Next, however, to ascertain the value of the land which is being offered by the petitioner, the registrar original side will inform the court of the panel of valuers, will inform the court, inform the court of a suitable empaneled valuer tomorrow when this matter shall be listed. Stop. Next, learned counsel, you're the advocate on record. The advocate on record of the award holder does not have any objection to the land being given as security for the award. List this matter on 26 July 2023. Next.
Well, the copy of the deed maybe kept on record, my lord. The deed.
It's a copy.
Copy of the deed.
Yes, yes. The copy of the a copy of the deed is kept on record. Next.
Item number 11, Ritesh Agarwal.
And for the respondent, it is the same matter.
Same,
It's a
Lord,
section 34 application.
Same matter.
Lord, as item number 7, which your lordships just heard.
The point of nativity is open, my lord.
Service, deemed service.
Deemed service.
Yes, the objection taken on behalf of the award holder on deemed service under the provisions of, under section 3 of the 1996 Act, section 27 of the General Clauses Act and section 114 of the Evidence Act is to be, will be considered tomorrow. List this matter tomorrow.
Grateful.
Next.
Item number 12, Sambit Basu. And for the respondent.
Section 34.
Ready? If you're not, then costs.
No, madam.
How much time will you take?
Points involved, my lord, very short. My lord,
How much time will you take?
10 minutes, not more.
10 minutes. That's too long. How much time will you take?
5 minutes, my lord, in that case. Only
34.
there are 3 points involved, my lord.
34.
My lord.
34.
Yes,
My lord, 34.
Which subsections of 34?
My lord, 34, my lord, ground C's of my lord, the subsection 2,
Sorry,
34, 2,
2, A or B?
A,
Which one?
clause 3.
3.
My lord, the notice has not been served upon. But 21 notice has not been served. First point is this.
Clause 3 is not notice not being served. It says insufficient opportunity
Not only that,
for representing your case.
I'm coming. My lord, 34,
You are Mr. Bhattacharya? You are Mr. Bhattacharya?
Mukherjee.
Sorry, Mr. Mukherjee. Why has the order recorded a wrong name? I'm sorry. Mr. Mukherjee, you come back on some other day, tomorrow, but be ready, please.
My,
Because I will take up my.
my
appellate
lord, I have some, my
appellate side.
Achha, let's-
Mr. Chidambaram, why did you take the trouble of appearing physically? If you had some other matter?
Part had matters, item number 1.
No, my lords, client is anxious that we should complete the matter today. So I said, physically, maybe I'll be able to go through it quickly.
Very well. Court's pleasure.
Does your lordship have the list of dates which I gave last time? I can give another copy, but there's a list of dates.
Last time is many months.
Some weeks ago. 3 pages, list of dates, yes. Now, my lady, I will not go through this list of dates.
Yes.
I just want to take 2-3 minutes to point out the material list of dates. I won't read it because of the reason that I will explain. Just look at serial number 3.
Mr. Chidambaram, I'm sorry, just pick up the thread, please, once so that it comes back to me.
Yeah, I'll as I go through the list, your lordship will recall.
Very well. So as of now, you want appointment of an independent auditor?
No.
Or is that prayer now gone?
That's all that is past us.
Yes.
Because R2 and R3, R3, there was never any dispute. R3 was a lead bank. It is stuck to the loan agreement. It has never varied it. R2 and R1 were fighting us. R2 has settled the matter. And I will tell that. R2 has settled the matter. It's R1 who is unwilling to settle the matter on fair terms. Pending the writ petition, R1 made one offer, which we rejected. After the last hearing, R1 made another offer, which we have rejected. If they are willing to make an offer which will enable me to recoup or recover the excessive and illegal interest they have charged, I'm willing to meet them more than halfway. But since they do not appear to be willing to meet me halfway, or at least somewhere near halfway, I have no option but to continue the matter.
Very well. So Mr. Kaur is for the Bank of Baroda.
Yes.
And you're the only contesting respondent now.
Yes. As of now.
Lordship has already passed an
Yes,
order
yes,
that the only contesting respondent is R1.
Very well. Yes, Mr. Chamrod.
I'll take just 3-4 minutes to quickly run through. Serial number 3 is the original loan agreement between petitioner and R3, which was a sole lender. R1 came in the year 2015, serial number 6,
Yes.
and R2 came in July 2015, serial number 8. And all three bankers shared the 210 crore into 70, 70, and 70 crore. On the first page, kindly look at serial number 8.
Yes.
Axis Bank, which is R3, which has always maintained this rate, 11.55. It breaks up into, and I'll explain during the course of my argument, 9.95 is what is called the base rate, and 1.6 is what is called the spread. I'll define, both are defined, and I will take. R1 Bank of Baroda, the only contesting respondent, charged 11.40 because its base rate was slightly lower, 9.9,
Yes.
and the spread was 1.5. Syndicate Bank, which is now merged into Canara Bank, R2, 11.5, 10% was the base rate, but its spread was 1.50. So more or less between 11.4 and 11.55, they signed the agreement, and that was the position. Now kindly look at serial number 9. I have executed a mortgage and a hypothecation fully securing the 210 crore. And in fact, my multiplier is 2.86, which I pleaded, not disputed, 2.86. My property, petitioner one's property has been mortgaged, which is a hospital and a teaching college, has been secured, and the security is well over the FACR, which I will explain presently. The fixed asset coverage ratio, well above that, 2.86. Now, kindly look at 3/3/2016. Because the Medical Council of India pointed out there is some deficiency in the faculty accommodation, petitioner temporarily purchased 93 flats from a sister company. It took possession, but the sale deed is not registered. The owner happens to be the sister company. The 93 flats are in the possession of the petitioner. Then they wanted me to create a charge on that property. We pointed out there are two obstacles. One, the loan agreement says borrower's property must be secured. If property is not registered in the name of the petitioner, that is one objection, one obstacle. The second was, in order to create a charge, I had to get a NOC from the Durgapur Development Authority, Asansal Development Authority. Anyway, the property is there. It's not as though it's movable property. I can carry it and run away. It's there. 93 flats are there. But I've already secured you enough. There's no need to secure it. But even to secure this property, charge on the property, there are two obstacles. While we were in negotiation, while we were talking in the joint lenders meeting, now, at the joint lenders meeting, kindly see serial number 12. It was raised at the joint lenders meeting. We were in correspondence. Now kindly look at serial number 17 and 18. At a joint lenders meeting, petitioner number 1 explained that they're awaiting NOC from the Asansol Durgapur Development Authority, and a charge would be created on the temporary asset once the same is received. Then between January 2018 and November 2018, multiple joint lenders meetings were held between the parties for finalizing the mechanism for creation of charge on the temporary purchase. However, the lenders were still in discussion about the methodology to be followed for creation. They could not agree on the methodology to be followed. Anyway, the property is there. We could not create the charge because of the methodology. Now, what R1 did was, in serial number 14, respondent number 1 addressed a letter denying the benefit of the concessional rate of interest on the credit facility and modifying the interest rates. That is the first letter. Then serial number 19, 5/1/2019, respondent 1 addressed a revised sanction letter to petitioner number 1, by which penal interest of 2% per annum was levied on the whole of the term loan, on the whole of the balance term loan, not on the alleged defaulted amount, because there was no default. My account was regular. Then there is a lot of correspondence. Then I kindly see serial number 24. He increases it to 17.15%. Serial number 27, that is respondent 2. They have now settled it. We are objecting it. And then kindly see serial number 32. Respondent joint lenders meeting was held, wherein respondent number 3, the lead bank, Axis Bank, expressed shock about the rate of interest being charged by respondents 1 and 2, because it had kept its rate of interest according to the original loan agreement. Then there is a lot of correspondence. Finally, we have no option but to file the writ petition at serial number 33, October 21. I'm leaving this list of dates so that your ladyship can look at it at any time, the pages number marked. This is broadly the story. The story, to sum up in one sentence, is R3, the lead bank, maintains its rate of interest. R2 initially appeared to support R1, but during the course of the writ petition, it has accepted its fault. Without admitting it, it's accepted its fault. And now offered me 7 point, what is it? 7.3, serial number 42, 7.3% prospectively. It had charged me and collected excess interest. But when I do the arithmetic, 7.3% prospectively for the balance of the tenure of the loan compensates for what they have recovered from me. Therefore, I've accepted it. From 11.5, it has come down to 7.3% prospectively. And the tenure of the loan is another 3 years, another 3-4 years. So once we do the math, what they have charged excess is more or less equal to the what they will charge for the remainder of the loan. So I've accepted it. So R2 is out of the R1 is the recalcitrant bank which insists that it charged correctly. But I ask myself, if it insisted it charged correctly, why is it making the 2 revised offers? The 2 revised offers were, first revised offer was for 11.25%, serial number 46.
So as opposed to 11.30 or 40.
No, 17, 14 and all have been charged in between. As against the original 11.40, it is now offered 11.25.
Yes.
With effect from September 21. That is the date after the writ petition.
Yes.
And when I rejected it, on 15th of June 23, pending the writ petition. Huh? Yeah, I know that. I rejected the offer. 15th June, they are offering 10% with effect from April 22 for the balance of the tenure. April 23, I'm sorry, April, I've written it wrong. April 23 for the balance of the, I have done the arithmetic. This does not compensate me for the extra about 54, 73, 18.78 crore that they've charged from me. I say this is illegal. This is arbitrary, irrational, contrary to the master direction and master circular of the RBI, which are binding. Your lordships have held it's binding, it's law. They are obliged to follow the master circular and the master circular, master direction and the master circular. And therefore, I'm before your lordship's court.
So, Mr. Chidambaram, has the master circular fixed a ceiling?
Master circular says when a consortium bank can differ from the other members of the consortium and to what extent. It is only on the base rate it can differ. One bank of the consortium cannot say you have imperfect security and therefore I'll charge you. The other banks or other bank accepts your security is perfect. This is irrational.
So
What
the
is the bottom two?
the margin of variation is only with regard to the base rate, not the upper limit.
Master circular allows a variation on the base rate. Only one. Number two, the master circular and the loan agreement says when a penal interest can be levied.
Yes.
The loan agreement says when the revised rate can be set. There is an initial reset date and an annual reset date. You can't jump the gun and revise it whenever you like. You can revise it only once a year. You can't revise it every 3 months. And I'll show that. So kindly keep this in the background and I will put it purely as a question of law. How the master circular, master direction and their own loan agreement are being violated. I'm stronger today than the day I filed the writ petition because R3 does not go back. R3 does not renege. R3 sticks to the original loan agreement. And R3 says the security is perfect. There's no imperfection in the security. And I am not revising the rate. And I'm satisfied that all the preconditions for the loan agreement have been met. Now kindly see serial number . Where is it? Serial number 16. Respondent number 3 addressed a letter to petitioner number 1 confirming that all the conditions precedent for disbursal of the credit facility have been fulfilled. And then kindly also look at serial number 32, which I read. Joint lenders meeting was held where respondent 3 expressed its shock about the rate of interest being charged by respondent 1. This is the background, and I will stick to the law on the subject. No. Now I have written submissions. I have.
So this is, Mr. Chidambaram, the rate of interest for the loan taken by you.
Yes.
From the consortium.
Correct. 70 crore each now.
Yes.
R3 70 crore is fully satisfied. No variation, no arbitrary revisions. Security is perfect. Does not insist on additional security of the 93 flats. All preconditions fulfilled. And I'm servicing the loan. He has no complaint. He is a lead bank who originally lent 210 crore, then downsold. I'm sorry to use banker's language, downsold the loan to firstly to R2 and then to R1, 70 crore. R2, who joined the consortium a little later, took 70 crore, was initially following R1, but realized its mistake and said, I will offer you 7.5 for the balance tenure. From 11.5 to 7.5, virtually 55% of 60%. And I'm satisfied because it compensates me for the excess they have charged. So we don't have to recalculate all that interest. At least in future, I'll be compensated. Therefore, we have accepted it. R1 is holding out, but R1 is holding out without any conviction of its courage of conviction, because it's reduced suddenly 17%, 15% has been reduced to 11.25 and then reduced to 10.
Except Mr. Chidambaram, holding out usually has a positive connotation.
No, but why is it holding out? when R2 and R3 have accepted, R3 never did anything wrong. R2 accepts its error, implicitly accepts its error and corrects it. Why is R1 holding out? He should settle it. If he is not willing to settle it, then your lordship will decide for us who's right and who's wrong. Therefore, my lord, this is the background. Now, let me quickly go through the submissions. Now, since I know your lordship's under a tremendous pressure of time, I've put the written submissions in writing, and I'm giving my learned friend a copy, and I'm giving you a copy, and I'm going to walk you through the written submission. This is broadly what I've said orally. I put the page number, etc., etc. If your ladyship.
Except, Mr. Chidambaram, your learned friend, Mr. Cord, doesn't look very happy at this sudden thrusting of a written submission.
If he is happy, there is no cause for me to be unhappy.
This is only to save time.
No, it's all right. But whichever is convenient for you.
No,
Mr. Kaur, you will get a lot of time for your written submissions. Yes.
Well, at the end of arguments, many courts say, give us a written submission. This time, in order to save your lordship's time, I prepared the written submission.
That is fine, yes.
So we'll just walk through it
Yes.
and I'll done. Petitioner number 1 is a non-profit society that has established a teaching hospital in a medical college. Kindly mark, we are a non-profit society. We are not here to exploit people. We are a non-profit society. And there are eminent people in the society.
Yes.
Respondent number 3 sanctioned a loan of 210 crore. I've given the volume and page. I'm not troubling your lordship. I don't think my learned friend will find an error, but if he finds an error, I'm obliged and I'll correct it.
Yes.
Applicable rate of interest is in Schedule 4. Fixed asset coverage ratio is defined at page 18. Now, kindly mark this alone. Initial spread reset date shall mean 31/3/2018. Now, what it means is, from the loan up to 31/3/2018, you cannot revise the rate. The first reset date is 31/3/2018.
Yes.
Spread reset date, this is all defined, shall mean the initial spread reset date, which is 31/3/2018. So up to 18, you could not have revised the rate. Subsequent spread reset date shall mean every 1 year after the initial spread reset date. So this supports my argument. Annually, you can revise it once, annually. The right to reset is in section 2.62A, page 93. Now, kindly look at page 93 of volume 1. Volume 1. There's only 2 volumes. I'll refer to only some documents. Volume 1. 93.
Yes.
Now kindly see 2.6A. 2.6(2) spread reset and revisions of applicable interest rate. The lender shall have a right to reset the spread of the applicable interest rate with respect to the loans on the initial spread reset date, which is 31/3/2018, and at every subsequent special spread reset date which is 1 year annually, and the borrower shall pay such revised applicable interest rate immediately on the following interest payment date. So this supports my theory. The right to reset is only on the initial spread reset date and every subsequent spread reset date. Over the page, just to complete it, look at liquidated damages penal interest. The borrower shall pay penal interest at the rate of 1%, kindly mark it, 1% per annum over and above the applicable interest rate on the defaulted amount. Only to the extent of the defaulted amount you can charge penal interest. In the event of default in any payment of interest, repayment of loans, etc. Defaulted amount.
And
not
the
whole
defaulted amount is ascertained here.
No, if I miss a installment of a loan, that is a default. If I miss a interest payment, that is a default.
So there is no default here.
No, as far as I'm concerned, I'm a regular account even today.
Very good. Yes.
My lady knows it becomes NPA on the 90th day.
Yes.
If I miss a installment date or an interest date, I can still pay within 90 days.
Before that, all this SMA, SMA2 and all that. is there?
SMA1, SMA2, and then NPA.
Yes.
I have never crossed 90 days for a short period when there was some difficulty in 2017-18 in the admission to 1 year. There was a delay, but not exceeding 90 days, about 1.5 months. And I immediately paid. That period interest will be paid. There's no difficulty. But penal interest can be charged only on the defaulted amount, not on the whole loan. I borrowed 70 crore. On that day, suppose 60 crore is balance. You can't charge penal interest on the entire 60 crore because the entire 60 crore is not the defaulted amount.
And Mr. Chidambaram, what is page 93 a part of?
93? Which one? What is your ladyship?
So what is the question? What is this document? Page 93 is part of which document?
This is the loan agreement. No, this is the original loan agreement
original
starting
loan
at page 65, I think. 65.
Very
I
good.
put it in the
Yes,
put it in the note.
Yes.
Now, just to complete it, 94, please see 3 also. 3 I've read. 4. Disbursements, if any, made pending creation of security shall carry additional rate. We are not concerned because security was created even when the loan was taken, etc., etc. It does not. Now, let me go back to my note. This is a 7th bullet. Penal interest at 1% per annum is payable over and above the applicable rate of interest on the defaulted amount. Primary security will be waive first charge on movable and immovable properties of the borrower. That is at page 101. I've created petitioner one's movable and immovable property have been secured. Additional security may be demanded only if FACR goes below 1.5 times the loan amount. Now, kindly see that at page 102.
Yes.
3.2. If at any time during the subsistence of this agreement, the FACR goes below 1.50 times, then the borrower shall provide and furnish to the lender to its satisfaction such additional security as may be acceptable to the lender to cover such deficiency. And our FACR is defined, as I said in the second bullet at page 80, about just below the middle, after fixed assets.
Yes, yes, I've seen.
Fixed asset coverage ratio shall mean the ratio of aggregate of basic value of land, net book value of the retaining fixed assets on which the lender has first charge to the outstanding loans. So page 80, read with page 102, stipulates 1.5 My position is 2.86. It was well over 2 always. It never came below 1.5. It is nobody's case. It came below 1.5. Now I've written petitioner number 1's FACR was always more than 2 times the loan amount of 210.3. Respondent number 1 and respondent number 2 wish to be part of the loan agreement and have equal shares. 24/4/2015 and 22/7/2015, first and second addendum to the loan agreement under which the loan was downsold to respondents number 1 and 2. Each bank became a lender of 70 crore, applicable interest rate. Your ladyship has already seen that. Now, the first figure in Axis Bank, for example, 9.95 is the base rate and 1.6 is the spread. And I'll tell you what the definition of spread is. Spread is defined. Where is spread defined? In the master. Spread is defined in the master direction. Wherever. Page 84 of volume 1. This follows the master circular. They're obliged to follow. Now kindly see the middle of page. Spread shall have the meaning as set out in Schedule 4 of this agreement, and such spread may be reset on the relevant spread reset dates. Now, Schedule 4 is at page, where is Schedule 4? 140. The applicable interest rate shall be payable. The spread which shall be applicable up to the initial spread reset date shall be determined as follows. Name of lender Axis Bank, base rate, spread is B equals C minus A, and C is applicable interest rate as on the date of sanction. Base rate is 10.15. Spread is 2.85, but he actually applied only a spread of 1.6 or so. Applicable interest rate shall be arrived at in the following manner. It is clarified that between any 2 consecutive spread reset dates, upon change of base rate, applicable interest rate will stand revised. Naturally, when the first component A plus B, A is revised, A plus B will get revised. Lender reserves the right to revise the spread if Reserve Bank of India revises the standard provision applicable, enhances, or any credit rating agency downgrade. Now mark this, I'll come back to this. Any credit rating agency downgrades the loan below the investment grade. Now I have a credit rating. External credit rating agencies rate me. ICRA, CARE, there are a number of agencies.
CRISIL.
If any
CRISIL also. CRISIL.
CRISIL. If anyone downgrades me, then you can do that. So credit rating agency, that the word agency is important. Now we'll come back. I'll come back to that. Now kindly go back to the list of submissions. Serial number 5. 22/7. Petitioner executed a memorandum of deposit of title deeds and supplemental deeds of mortgage and hypothecation, thereby perfecting the security for the credit facility extended by R1 to R3. 6, I've already told your ladyship. Medical counsel pointed out, and I bought this property on a temporary basis, infusing money by the promoters. This was not from the loan. The 93 flats were not bought from the loan. I bought it out of my other money. Respondent number 1 and 3 insisted that petitioner should create a charge in favor of the lenders of the 93 flats. Petitioner explained the nature of the transaction, also suggested that a tripartite agreement may be executed to allow future sale of the flats purchased temporarily. Once I build the regular accommodation in the hospital and college, I don't need these flats. I should sell them and recover my money. Once I mortgage to them, then it's impossible to sell it to them because they will not permit the security to be sold. Therefore, I said the tripartite agreement, I will create a charge on this property, provided they allow me to sell it when it becomes necessary. We couldn't agree on that. April 2016, respondent number 1 began to charge 12.35% contrary to the loan agreement. Now, please see, under the loan agreement, his rate is 11.4, 9.9 plus 1.5 spread. He is now charging 12.35. April 2016, when the initial reset date is only 31/3/2018. He is doing it before a good 2 years before the initial reset date. Respondent 1 addressed a letter denying benefit of concessional rate on the credit facility and modifying the interest rates. Petitioner objected to the aforesaid letter and emphasized that the credit facility had been adequately secured. This is important. I have addressed it. Respondent number 3 addressed a letter to petitioner number 1 confirming that all conditions precedent for disbursal of the credit facility had been fulfilled. This is in volume 2, page 283. Would your lordship or would your ladyship be good enough to see that? It's a short letter. It's a very important letter. 283. There's no attempt in the reply affidavit of opposition to deal with this letter at all. No attempt at all. Please see this letter.
This is by Axis Bank.
This is Axis Bank, the lead bank. We hereby state, as of the date hereof, we have not received an unsatisfied condition precedent notice from any lender, So neither Syndicate Bank or Bank of Baroda told the consortium there is an unsatisfied condition precedent. Based on the information supplied to us by the borrower, we also confirm that the condition precedent has been fully satisfied. Now, when I mention this, there's no attempt to deal with it. Why is this letter wrong of the lead bank? This is serial number 11. 12. Petitioner number 1 awaited an NOC from the Asansol Durgapur Development Authority in order to create a charge on the flats. Pending the NOC, a mechanism for creation of the charge was discussed with the lenders. However, between January 2018 and November 2018, the minutes are all there in the paper book, the lenders were still in discussion about the methodology to be followed for creation of charge. Not denied in the pleading of in the affidavit of opposition. 5/1/2019, respondent number 1 sent a revised sanction letter, YD, which penal interest kindly mark at 2%. Agreement says 1% penal interest, 2% per annum was levied on the whole term loan. 1% on the defaulted amount becomes 2% on the whole term loan.
Yes.
Petitioner objected through several letters. All this is in the list of dates. 30/11/2019, respondent number 1, rejecting the objections, revised the interest rate to 17.15%, allegedly due to fall in the mark this internal credit rating, his own credit rating, not a credit rating agency's downgrading.
What does this mean? Allegedly due to fall in
No,
the.
that is what he alleges. Your internal credit rating has fallen. I'll show that letter.
Yes.
His own credit rating. The agreement says credit rating agency. He's not the credit rating agency. He's a lender. His own internal credit rating allegedly has declined, as far as I'm concerned, on the account of the petitioner, an imposition of penal interest due to what? Due to alleged non-perfection of security. Now, this letter, your lordship will get at page 309. I missed to mention that. Your ladyship may kindly note here, volume 2, page 309.
Yes.
And serial number 15, it's volume 2, page 309. Pencil, pen up, pencil.
Yes.
Volume 2, page 309.
Yes.
I should have put it there. I'm sorry. Now, please see. We refer to your sanction letters wherein it is mentioned that rate of interest on account depends upon internal credit rating. Wrong. Plainly wrong. It's external rating agency of the accounts MCLR SPI guideline of bank or RBI changes from time to time. Inter-credit rating of your bank, your account, based on ABS, that is all his number, and your account also attract penal interest of 2% due to what? Non-perfection of security. Hence, applicable rate of interest increased to 17.15. He's wrong on every account. On every head he mentions there, he's wrong. Let me read on. 16. Correspondence between petitioner number 1 and respondent 1 ensued. 17. At joint lenders meeting, respondent number 3 expressed its shock about the rate of interest being charged by respondent 1.
3 is who? Axis.
Access. Yeah, your lordship read that letter.
Yes.
17/8/2021. That letter was at page, I showed that letter.
Doesn't matter, Mr. Chairman.
Yes. Then October 2021, when he raised it to 17.15, I had no choice but to file a writ petition. Respondent number 3 has throughout charged interest as per the loan agreement. Penal interest was never imposed. It had categorically stated all the preconditions of the loan agreement had been satisfied. Respondent number 2, Syndicate Canara, although initially charged interest in variance with the loan agreement and also charged penal interest, has, pending the writ petition on 14/6/22, settled the issue and has agreed to reduce the interest rate to 7.3% from the original 11.5, 7.3% prospectively till the balance tenure of the loan. This is can number 5, page 37, which we filed, and your ladyship has been pleased to accept it and order that the writ petition no longer survives against R2. On balance, the petitioner number 1 found that respondent number 2 had charged excess interest of 9.82 crore up to April 22, and that the offer to reduce the interest rate to 7.3% prospectively till the balance tenure of the loan compensated for the same. Hence, petitioner number 1 settled the matter with respondent number 2 and withdrew the writ petition insofar as respondent number 2 is concerned, and this was recorded in the order dated 24/6/22. Hence, the writ petition survives only insofar as respondent 1 is concerned. On 4/4/23, respondent number 1 offered to revise the interest rate to 11.25% with effect from 18/9. Petitioner number 1 rejected the offer. On 15/6/23, respondent number 1 offered to revise the interest rate to 10% with effect from April 23. Petitioner number 1 rejected this offer too, because neither offer compensated for the excess of, kindly mark, my lord, 18.72 crore charged and collected by respondent number 1 until May 23. The submission, my submission is So the offers of the respondent number 1 are a clear admission that the interest rate charged and revised upwards from time to time since April 2016 was contrary to the terms of the loan agreement. Otherwise, why would he offer? I ask myself, why would he offer from 17.25 to 11.25, a sharp drop of 6%, and then a further offer of another 1.25 if he was completely right, and if he filed an affidavit of opposition defending his position, why does he make this offer? Obviously, somebody must have pointed out to him that what you have done is wrong. Anyway, be that as it may. 23. The first date on which respondent number 1 revised the rate was April 2016. It was revised to 12.35. Supplementary affidavit to CAN, etc. That is not in dispute. The submission is that, the legal submission is that this is contrary to the initial reset date, which has been fixed as 31/3. On this ground, this should go. You can't revise it before the initial reset date. Then, 24. But the same letter dated 1910, respondent number 1 alleged it was increasing the interest rate till perfection of security. I read to your ladyship the read. The submission is this. After becoming a part of the consortium, respondent number 1 issued its first sanction letter dated 30/3/2015, in which it fixed the FACR at 1.27. Now kindly see volume 1, page 162. When he joined the consortium, his own letter says FACR is 1.27, page 162 of volume 1. Where is it? Not 161. This letter starts at 162 at 173. I've written that. At 173, the long letter, foot of the page, financial covenants for the society, FACR is 1.27x. Foot of the page.
Yes.
1.27. His own sanction letter says FACR is 1.27. I have never gone below 2. On this ground, also, his revision of interest rate is wrong. FACR of the petitioner was always more than 2x. The further submission is, even if the security was not perfect, as per the first sanction letter of respondent 1, respondent 1 could only ask the borrower to create security on additional assets. Please see that at page 162 at 174. The remedy is not to charge additional interest, but to ask for more security. 174.
Yes.
Remedies provided in the same document. Top of page 174. In case value falls below the stipulated cover, previous page 1.27, the borrower shall create security on additional assets in favor of the lender. Where does, I ask myself, and I'm sure the learned friend will answer, where does he say your FACR fell below 1.27? I asked you for additional cover. You therefore did not give additional cover, and therefore under clause so-and-so, non-existent, I'm entitled to charge 1%. On all three heads is wrong. My FACR never went below 2. He never asked me for additional cover. And there is no provision to charge interest rate for allegedly going below the FACR. Respondent number 1 could not increase the interest rate on the alleged ground of imperfection of security. Hence, respondent number 1 acted illegally and arbitrarily. I asked myself in my discussion, why did he not ask for additional cover? And the answer is obvious, because respondent 3 has said, you have fulfilled all the conditions of the loan. And respondent 3 does not want additional security. Anyway, 25.
Mr.
But-
Chidambaram, will you be able to finish by 4?
Yes, yes, yes. I'll finish.
By 4?
What is that?
There's a,
Ah,
yes,
maybe 5-10 minutes, 5 minutes more. I'll finish this. It's only 2 pages. No?
yes.
I'll finish it. That's one of the reasons why I wrote it out. By letter dated 5/1, respondent number 1 issued a revised sanction letter levying penal interest at 2% per annum on the whole term loan. I've already made my submissions. Last time he levied it, that is bad. The submission is, the account was a standard account throughout and had never been declared NPA. I asked my learned friend to show a single document where my account has been declared irregular or an NPA. Besides, penal interest, even if leviable, your lordship saw that, can only be charged, imposed on the defaulted amount. Hence, respondent number 1 acted illegally and arbitrarily in imposing penal interest at 2% per annum, besides imposing it on the whole outstanding term. In the loan agreement dated 22/11, there is a provision which stipulates lender reserved the right to revise a spread if any credit rating agency downgrade the loan below the investment grade. The reference is clearly to an external credit rating agency. In the first sanction of respondent number 1, it used the words credit rating of the borrower. Carefully omitted the word agency. These words must be read to mean the same as in the loan agreement, because in the first addendum dated 24/4, under which respondent number 1 became a party, it was clearly stipulated in Article 1B1 that this addendum shall be construed as an addition to and supplemental to the loan agreement and not in derogation in any manner thereof. Volume 1, page 200 at 206, I've quoted it. Further, in Schedule 4, it was stipulated all other terms and conditions of the loan agreement shall remain in full force. Respondent number 1 has not pleaded that any external credit rating agency had downgraded petitioner number 1. In any event, under the loan agreement, section 2.62b, any downgrading of credit rating will be reflected in the spread. Once the spread is revised, there cannot be an additional interest for the alleged downgrading of credit rating. Volume 1, page 69, I'll show that. This is consistent with the master direction of respondent number 4, chapter 4, so and so. I'll show both documents. Now kindly see volume 1, page 69. His own loan sanction agreement, the loan agreement, original loan agreement. The addendum by which he joined is only supplemental. Kindly come to page 93.
Yes.
Yeah. Kindly come to 2.62b. The lender also have a right to reset the spread in the event of revision of guidelines by RBI and or enhancement of the risk weight for the assets and or downgrading of credit rating of the loans below the investment grade from the date of intimation by the lender. So for downgrading, you can only increase the spread. Having increased the spread, you can't charge another interest rate for downgrade. And this downgrading is by an external credit rating agency.
Yes.
Now, this is consistent with the master direction, which is in a convenience compilation. Madam, this convenience compilation. Master direction of respondent 4. This is consistent with that. Now, kindly see convenience compilation, page 25 at 32. Spread. P is spread. There was a base rate system,
Yes.
and then it moved to a marginal cost of lending rate, MCLR system. Your ladyship need not trouble with the system they follow. Base rate was replaced by MCLR, that is internal between the Reserve Bank and them. We are only concerned with the first number, which is base rate, and then it became an MCLR rate. Now kindly see spread. B1. The credit risk premium. The spread is the credit risk premium. The credit risk premium charged to an existing borrower shall not be increased except on account of deterioration in the credit risk profile of the customer. So if there's a downgrading of the credit rating of the credit risk, both are the same. Credit rating and credit risk are two sides of the same coin. Then you can increase the spread. The same
That's
thing
the
is there.
same as page 6, Mr. Chidambaram.
Beg your pardon?
That's the same as page 6 of this compilation. 3.5 III, page 6.
Yes, page 6, 3.53. That
Yes.
is the master circular.
Yes, and this is
This
the
is the
master
master
direction.
direction.
Very well.
I'm reading the second one, but it's the
Yes,
same.
yes,
Your ladyship is right. Then kindly come to C. After the MCLR system, C over the page, C2, same. The credit risk premium charged to the customer representing the default risk arising from loan shall be arrived at based on appropriate credit risk scoring model and after taking into consideration, etc. The spread charged to an existing borrower shall not be increased except on account of deterioration in the credit risk profile of the customer. So he can't charge for downgrading something other than after having increased the spread over the page. Now, his reply affidavit is a unusual affidavit. I can't understand many parts of it because it's self-contradictory. In its affidavit of opposition, respondent number 1 has made the contradictory statements. In paragraph 3.7, respondent number 1 has stated that applicable rate of interest was 14.5% per annum. Additionally, 2% penal interest was charged. I'm quoting exact words. This is there in paragraph 3.7. The word is additionally. In paragraph 3.11, respondent number 1 has stated applicable rate of interest was 14.15, including 2% penal. The word is included, including 2% penal interest for imperfection of security. As I pointed out, imperfection of security does not allow him to charge a penal interest. Further, it is stated that so long the writ petitioner does not give the said 93 flats as security, the bank will continue to charge 2% as penal interest on account of imperfection of security. So 3.7 and 3.11 are directly contradictory. In paragraph 3.13, respondent number 1 has given a table which has no clarity at all and has added a footnote. There are 2 asterisks and it says penal interest of 2% extra levied as and when account was overdue on overdue amount only, contrary to his letter which says the whole amount. Here the note says on overdue amount only. Below that, there is a statement that further 1% of additional interest was charged for downgrading of credit rating. For downgrading, he cannot charge. Then, these statements are mutually contradictory as submitted already, downgrading by an external credit agency risk alone would be relevant. And in any event, such downgrading would be reflected in the spread. No additional interest can be charged for alleged downgrading over and above the spread. Besides, if the security is allegedly imperfect, respondent number 1 can only ask for additional security and cannot increase the interest rate. So he's tying up a certain knots in saying various things in the reply. Then, respondent number 1 is admitted in paragraph 313 that the account was regular till 31/1/22. That is until after I filed the writ petition. And it was also regular on 16/3. What he means is between 31/1 and 16/3, I had perhaps delayed payment of an installment by a few days, but 31/1 and 16/3 is only 44 days. I have not become NPA.
Yes.
I have not become irregular. I may have become irregular after 31/1, but I became regular on 16/3. That is his own admission. There was never any default of 90 days, which alone would lead to the account being classified as NPA. As regards respondent number 1 statement in paragraph 316, the reference to RBI's master circular dated 1/7/2015 is presumably to paragraph 6, which your lordship just pointed out at page 6. Your lordship pointed out spread.
Page 6.
He's referring to page 6. This is perhaps what he's referring to.
Yes.
Because he doesn't mention the paragraph, which allows a bank part of a consortium to charge an interest rate different from the uniform rate only to the extent, it's not extent, Miller, only to the extent that such rate of interest is determined with reference to its base rate. Now, please see that. Paragraph 6. I don't know what he's referring to, but the only possible reference is to paragraph 6 or page 6 is spread, and paragraph 6 is what I thought he was referring to. Paragraph 6 is at page 10. Banks need not change a uniform rate of interest, banks need not charge a uniform rate of interest even under a consortium arrangement. Each member bank may charge a rate of interest on the portion of the credit limits extended by it to the borrower. This is important. Subject to the condition that such rate of interest is determined with reference to its base rate. So there are two components in a bank rate: bank base rate and spread. Consortium may charge one rate, but you may differ from the consortium, but subject to the condition that it is determined with reference to the base rate. Because I'll tell you, Lordship, why. It is logical. Spread includes credit profile. Spread includes the credit risk of lending to the borrower, depending upon the borrower, the project, the sector in which the project is located, the geographical location of the project. All this based on the credit risk will differ. Suppose a steel factory is located, or a producer who produces inputs for a steel plant is located, say, 10 miles from Bhilai or Durgapur. Obviously, the risk is much lesser. Suppose it's located in this district called Gadicharoli in Maharashtra, which is Naxalite infested. The risk will be greater. I understand. But spread takes care of all that. If there are 3 or 10 or 7 banks in a consortium, they are a consortium. They want to share the profit of a loan arrangement. They discuss and decide what is the risk of this profile. risk of this borrower, risk of his project, and they agree on a spread. Each one can't differ from that spread. You can only differ to the extent of the base rate. Your base rate may be higher or lower, depending upon the applying the master circular, your asset quality, etc. of the bank. This is dependent on the bank. That's why very carefully RBI says you can differ subject to the condition that such rate of interest, that is the differing rate of interest, is determined with reference to its base rate. I'll read on. Last 4 lines. It is submitted that the base rate may change from bank to bank, but no bank as a part of a consortium can be allowed to charge illegal and arbitrary interest as penal interest, because penal interest is only on defaulted amount, or interest for imperfect security, which there's no provision. You can only ask for additional security, or interest for downgrading of credit rating. That is not permissible because that is included in the spread, and it again depends upon an external rating agency. Therefore, it is submitted that the statement in the reply at paragraph 6, page 17, to the effect that the interest rate charged by respondent number 3 is irrelevant, is an astonishing statement. Respondent number 3 was the original sole lender and lead bank of the consortium, and the consortium nominated him as a lead bank. And throughout this period, respondent number 3 had maintained the interest rate without any illegal or arbitrary changes.
Mr. Chidambaram, I will read the last 2 paragraphs.
Yes, he collected 70.38,
Yes,
whereas petitioner number 3 only collected 56.63.
yes.
Attached to the written submissions table. Now, I'll take 2 minutes to explain the table to the extent best of my ability, but my ability won't be good because nobody can understand this table. I'm sure my learned friend will explain it and I will rejoin. What is this table? What does it mean? I don't know.
So, Mr. Chidambaram, better way would be for Mr. Court to explain the
Yeah, that is
table,
what I'm
and then you can respond to that.
I say that.
Yes,
Let him explain this table.
yes.
I'll tell you what this table is. This is about R1 bank. Each row is given the agreement rate, the base rate, etc. And what he actually charged is in column 4. The breakup of column 4, to the extent we have understood it, is in column 5. And our remarks are in column 6. Now, you will find that his rate has been 11.8, jumped to 14.15, 16.40, then 15.2, 15. Then he made an offer of 11.25 and 10. He has to explain how column 3 was arrived at. To the extent we have understood from his reply, column 3 is arrived at by column 4. Column 4 is illegal for the various reasons I mentioned. He's charged penal interest of 2%. He's charged, in addition to the spread, he is charged interest for the alleged imperfect security, which is not permissible. This is what he's charged. And rate of interest of be actually charged, I've given this period where he actually, this is a calculation in the
Mr.
reply.
Chidambaram, let me process all this.
No, page,
Alright.
column 5 alone, I'll explain. Column 3 is what he says in a sanction letter. But what he actually charged me is in column 5, which is different. When he was saying 11.1 plus 1, 12.2, he actually charged me up to 12.45. So look at the roll 3. When he was telling me I am charging 14.15, he actually charged me 17.15.
Very well. Are you done?
And I am done. On that, and after
Thank
he
you.
replies, I'll rejoin.
Thank you.
Obliged. Brothers.
Mr. Kaur, when should we put this matter?
Sometimes next week, whenever it's convenient, Your Lordship.
What?
This is an assigned or a part-heard matter? Part-heard.
Part-heard matter.
So it has to be on a either 2nd or 9th.
I've already given you a list of judgments on the various heads. Writ is maintainable, writ against public sector bank, I've given the
But
list.
he must indicate which are the judgments he is relying upon, not all the
Why, all of them,
30 judgments he has
No,
given.
not 30, I'm relying on all.
Very
I'm
good.
relying on all. I'm not reading all, I'm given the paragraph, I'm relying on all.
Yes, but Mr. Chidambaram, I will not be referring to all in my
No,
judgment.
no, that is entirely your ladyship's
So you will have to point out whenever as to which judgments you
I'll point out
specifically
the
want to rely
rejoinder.
on and for which
I'll
point.
select it, but I've given
No,
the.
not in rejoinder, otherwise I can't deal with it.
No, no, you have to.
I don't have to deal with 30 judgments.
It is not 30 in the
List of
first
judgments, that's
place.
it.
It is the same proposition.
List of
If you
judgments.
push me, I will say I'm relying upon all.
Right. Rely upon all, but must point out what are the paragraphs that you are relying upon.
I've given that also. Paragraph number is also given.
Very well.
List of judgments.
I'll
Lord,
give
he
an.
has given a one-page, Lord.
I've given this.
Yes, you have given that.
So that is what you have given, Mr. Chidambaram. Then we don't have to worry much about that.
That's what I've given the paragraph number. And if my learned friend.
Very well, very well. I take that he has
Yes,
cited each one of them on these propositions. I proceed on that basis.
If there's
So
anything-
Chidambaram, you just tell me which is your best,
I'll do
best
that.
case. on
I'll
the
do
next
that.
one.
I'll do that before he starts next month.
Yes. Yes.
I'll do that.
So you tell me which second or ninth?
Whatever he wants.
It's a Monday, I'm told. So
August
31st
2nd
or,
is with.
no, 31st or 7th. It should be Monday, not
I
Tuesday.
see.
31st or 7th?
Kindly keep it on the 7th then.
7th.
You want to keep it in second?
7th. 7th.
7th August is fine.
Very well. Yes. Learned counsel appearing for the petitioner. Petitioners will conclude his submissions on 7th August 2023. And learned counsel appearing for the respondent number 1, Bank of Baroda, will commence his arguments on that date.
I'll take 5 minutes on 7th to indicate which judgments I'm relying upon.
Yes, yes, please.
And I'll give a compilation.
Yes, thank you.
Obliged.
Compilation, Mr. Chidambaram, only the judgments which you want to
Only
rely-
only the judgments I indicate, I'll give a compilation.
Yes.
Compilation.
Any other matters which are urgent today? Because I will be rising. Anyone waiting for a matter which is urgent?
May I excuse myself?
Yes, yes, please. Thank you. So all these matters will go Kobe, Budhbar din. The part heard matters will go on Monday and the other matters will come on Wednesday, the next appellate side day.